start doing that now. Great. Okay, so now we're streaming. We also have a number of attendees joining us in the attendee portion of our webinar this morning. Welcome and good morning. We are the Health Coverage Insurance and Financial Services Committee, and we are live on YouTube as well as on Zoom in the webinar format. We have a number of different tasks before us this morning, including a public hearing and then a number of work sessions. We are going to begin this morning, as we usually do, with committee introductions. And so I feel like I just lost a bunch of people on my screen. In any case, we will start this morning with Representative Connor. Representative Connor, go ahead.
Good morning. My name is Representative John Connor. I represent the people of House District 58, part of Lewiston.
Representative Quinn. Where did she go? Okay, so she was one of the ones I lost. There she is. She's coming back. All right, we'll go next to Representative Evans and we'll come back to Representative Quinn. Oh, we haven't got Representative Evans yet. Representative Tepler, would you mind texting Representative Evans and see if we can get him some assistance in finding the right link? Thank you. Representative Quint, go ahead and introduce yourself.
Hello, I'm Representative Quinn Tracy. I'm from House District 144, and I serve Holton, Hodgson, Amity, Cary, Weston, Haynesville, Silver Ridge, and all together there's 14 districts. I hate to leave anyone out, but hello.
Excellent. Representative Arford.
Thank you, Madam Chair. My name is Representative Poppy Arford. I represent House District 49, and that includes the western part of Brunswick.
Great. Representative Brooks.
Good morning. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Representative Matheson.
Good morning. My name is Christy Matheson. I represent District 1 in Kittery.
Representative Melrano.
Good morning, everyone. My name is Gina Melrano. I represent House District 62, which is part of Auburn. My apologies, I'm having just a little bit of technical issues here without being able to connect my camera to Zoom this morning. Hopefully I will be able to later. Thanks.
Great, thanks. Representative Blyer. Oh, we don't have Representative Blyer yet. Representative Evans has joined us. Representative Evans, please go ahead.
My name is Richard Evans. I am the representative for House District 120, Dover, Foxcroft, and about 7 surrounding towns.
Great. Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent the towns of Turner, Leeds, and part of Livermore, House District 75.
Senator Stewart.
Good morning. My name is Trey Stewart. I'm State Senator in District 2, which includes 51 communities in Southern Aroostook and Northern Penobscot counties, including the town of Lee.
Great. Senator Brenner.
Good morning, Madam Chair. My name is Stacey Brenner, and I'm a senator from Senate District 30, which is part of Buxton, all of Gorham, and most of Scarborough.
Great. Representative Tepler.
Good morning, everyone. My name is Denise Tepler. I represent House District number 54, which is all of the town of Topsham, and serve as House Chair of the committee.
Great. And I'm Senator Heather Sanborn. I represent District 28, which is half of Portland and half of Westbrook. Welcome, everyone. I won't go through the whole spiel, which I've done sort of every day since we started on Zoom a couple of weeks ago, but I will just remind everyone that we are live on YouTube. So if you do not want to accidentally broadcast anything that shouldn't be broadcast, please do put yourself on mute. And if the chairs hear your microphone hot when it shouldn't be, we will try and mute you as well. So please don't take offense, but we are trying to just protect all of you from not accidentally making any comments that shouldn't be broadcast. We are all joining from separate places as well. And so you may hear some interruptions from children, dogs, house phones, and so forth. Please bear with us, and we're all trying to figure out this work from home or work from wherever you are kind of situation in 2021. Okay, so our first order of business this morning is that we will be taking up our first substantive rule. And so we've asked, oh, I also didn't introduce our clerk and our analyst, so definitely want to do that. We couldn't do this without them. Christian Ritchie has been our master of technology and just wonderful assets so far this year. And then Colleen McCarthy-Reed serves as our OPLA analyst. So with that, I'm going to ask Colleen to give the committee a bit of an overview of the substantive rule process and review process so that we know the parameters of our task before us before we open the public hearing on the rule before us this morning. So Colleen, go ahead.
Okay, great. I'm going to share my screen here. Hopefully that works for everybody. I do have two screens going, so I may be looking away as I present to you. But as Senator Sanborn said, this is going to be the committee's first opportunity to review a major substantive rule. And so before you started the hearing, we just wanted to give you some brief background on this process, sort of where it came from, the legal authority, and sort of how the committee, what the committee's role is in reviewing major substantive rules. So this is a handout that was developed by our office, the Office of Policy and Legal Analysis, as hopefully a handy guide for legislators to give you an overview. And this will be posted to our committee materials website later, so you can go back and have it as a reference. But before an agency may adopt a rule on any matter, the legislature must have enacted a law granting the agency that rulemaking authority. And any rules adopted by a state agency must be consistent with the law under which they are adopted. There's also a process in statute. It's called the Maine Administrative Procedures Act. And the rules must undergo and follow that process, sort of a public process that the agency must go through in accordance with the statute to adopt a rule. In 1996, the legislature made some substantive changes to the Administrative Procedure Act and enacted a law that requires that those laws that are enacted after January 1, 1996, that delegate rulemaking authority to an agency must include language that specifically indicates whether those rules are what's called routine technical or major substantive in the statute. The APA, the statute, does set out some criteria that the legislature can use in determining whether or not they want to designate a rule as routine technical or major substantive, but the ultimate decision whether a particular rule is routine technical or major substantive is made by the legislature when it enacts the law that authorizes adoption of the rule. And the statute does sort of generally provide some guidance and a definition of what might be thought of as a routine technical rule. Routine technical rules are those rules that would establish standards of practice or procedure for an agency, including, for example, rules that might set a fee within a range specified by statute. Major substantive rules would be those rules that, in the judgment of the legislature, either might require the exercise of significant agency discretion or interpretation and drafting the rule, or those rules that might reasonably be expected to result in a significant increase in the cost of doing business, a significant reduction in property values, reduction in government benefits or services, or put a serious burden on the public or units of local government. But again, the key consideration for the legislature when they're enacting statutes that designate rulemaking authority to an agency really is whether or not the legislature wants to review the rule before it's finally adopted by the agency. And if they do, the legislature designates those rules as major substantive, and it triggers this formal legislative review process that we're going to be going through today with regard to the rule adopted by the Maine Health Data Organization that's before you as part of LD 41. Those rules that the legislature designates as routine technical are not subject to this additional legislative review process. They are still subject to the same Administrative Procedure Act procedural requirements related to agency rulemaking. There are requirements that the agency must provide notice of their proposed new or amended rules to interested parties, the general public, and to the legislature. The agencies must accept and respond public comments on the proposed rule. And then those rules are also reviewed and approved for legality by the Office of the Attorney General. So the process that the agency undergoes is really the same for a routine technical rule or a major substantive rule, except that if it's a major substantive rule, the statute does require that the agency formally hold a public hearing as part of the APA process. Once they have completed this process, when it is a major substantive rule, the statute allows that rule is what's called provisionally adopted by the agency. So it does not have legal effect until it has been reviewed by the legislature and finally adopted by the agency. So that's the stage that we're at right now with LD 41. The agency has provisionally adopted the rule, but it won't have legal effect until the legislature has completed its review and authorized the rule to go forward or not, and that rule has been finally adopted by the agency. And again, the contrast is that routine technical rules do not have to go through this additional legislative review layer. When an agency does adopt a major substantive rule, they are required in the statute to notify the legislature, and they submit certain documents, background materials for the rule. And I did email out those background materials to you yesterday. So you should have received by email a copy of the rule itself, the basis statement, which summarizes the written comments that were received on the rule and the agency's response, and some of the additional background material, including the statutory authority that designated the rulemaking responsibilities to the Maine Health Data Organization. Once those rules are submitted to the legislature prints a resolve, and that's LD 41. And then the resolve is the vehicle through which the committee completes its review and makes a recommendation to the full legislature as to whether and how the rule should be adopted. There are some criteria in the statute that the committee will be considering when we do get to work sessions on the rule. But just wanted to summarize briefly for you the committee's options after you have had the public hearing and we get to the work sessions. The committee will be taking a vote in work session, and the options that the committee has are they may authorize the agency to finally adopt the rule, to move forward with the rule as drafted by the agency. The committee may direct the agency to make some changes to the rule, or the committee may designate part of the rule as moving forward and reject other parts of the rule. The second option that the committee has is the committee may decide that they don't want to authorize the agency to move forward in any way with finally adopting the rule, and they do that through their recommendation on the resolve. In terms of the timing of how the legislature does this. The committee's recommendation on a major substantive rule that's submitted to a legislative session must be reported out not less than 30 days before statutory adjournment. So we're starting off early, so we shouldn't have any problems meeting that deadline. The last thing I just wanted to mention, that in the event that the committee fails to act or the legislature fails to take action on a major substantive rule that's been submitted to the legislature, it does have some effect on whether or not the rule can move forward. If the committee failed to act during a session when it's been properly submitted to the legislature, the agency is allowed under the statute to finally adopt the rule as drafted. So it is important for the legislature to make its recommendation known formally if they want the agency to move forward or not. If the legislature does not wish to authorize final adoption of a rule that's been submitted in accordance with the statute, they must formally pass legislation that prohibits them from doing so to counter the effect of the statute as it's drafted now. Those same rules don't apply if the rule has been submitted late, but in this case, LD 41 has been submitted within the guidelines. So if the committee decided not to take the bill up for some reason and there was no action or recommendation made on the rule, it would be able to move forward and be finally adopted by the agency. And then the last thing I would mention quickly is that once the legislature takes action on legislation that approves the rule, the agency is required to finally adopt that rule within 60 days of the effective date of the legislation approving the rule, or within 60 days of the adjournment of the session if the legislature fails to act. I would note that if you take a look at LD 41, it is drafted as an emergency resolve, so that if the committee does move forward and authorize the Maine Health Data Organization to move forward with the rule either as drafted or with some amendments, they would be able to do that immediately upon the legislature's enactment and the signing of the legislation by the governor. I think that's it really quickly. Overview of the process. We'll talk more about the criteria that the committee will use to review the rule, but I'm happy to answer any questions now or at our work session. I'm gonna stop sharing.
Great. Thanks, Colleen. Committee members, does anyone have questions for Colleen on the process that we're about to undertake? Okay, seeing none, I am going to ask, I'm going to ask Colleen, who is the sponsor of LD1? 41. Denise is, okay.
Technically,
all
yes,
right.
Representative
Okay.
Kepler.
Great. So, so how we're going to do this is that we are now going to open a public hearing on LD 41. And we're going to invite the sponsor to present her testimony.
Thank you, Madam Chair. And I apologize to the committee for not submitting written testimony. I did not realize that my testimony was part of the introduction of this major substantive rule. I will leave all questions to Karen Lee Harrington, the executive director of the MHDO. But I do think it's really important that this rule or some form of this rule be adopted in order for us to track some of the changes in prices in pharmaceuticals. We have found in the past that various agencies point fingers at each other as having blame for price changes, and tracking this information with data that also can be compared across data sets with other national data sets will help us to understand where high prices in drugs are coming from. So thank you for the opportunity to introduce this bill, and I will answer any questions I can possibly answer, but would prefer you direct your questions to Ms. Harrington.
Thank you, Representative Tepler. So I have already promoted Ms. Harrington into the meeting, so she's now joined us. And Ms. Harrington, if you want to turn on your video and your microphone, the floor is yours.
So good morning, everyone. Senator Sanborn, before I get started, do you want me to provide a brief overview of the MHDO, or do you want me to jump into my testimony?
Yeah, no, I think it would be fine to provide a brief overview. If we can try and keep it to like 5 minutes or so, that would be great.
I am setting my timer.
Perfect.
Here we go.
Thank you.
So good morning, Senator Sanborn and Representative Tepler and members of the committee. My name is Karen Lee Harrington, and I work with the Maine Health Aid Organization, and it's great to be here with you this morning. I had forwarded to Colleen, and I'm not sure if you've had a chance to look at it, but a briefing document that probably provides more detail than you want to know about the Maine Health Aid Organization, but it tries to put into one place all of the different activities that we are responsible for. And just for the newer members that aren't familiar with MHDO, we were created by the legislature back in 1995 as an independent executive agency, which basically means I serve at the pleasure of a board of directors. The board of directors are appointed members by the governor, and they represent a broad group of stakeholders, including payers, hospitals, providers, home health care, chiropractors, consumers, employers, and government. And the primary purpose of the Maine Health Aid Organization is to create and maintain a healthcare database. And we do that so that researchers and others, including folks in state government, can use the data to help improve either the costs of healthcare, or at least the understanding of the costs and quality, and really to promote transparency around the cost and quality of healthcare in the state. And so we do that through different ways. And again, one of those ways is a website called Compare Maine, which we talked about briefly yesterday during the appropriations discussion. And I would be more than happy to come back and specifically talk about Compare Maine. But what I wanted to focus on in a few minutes that I have left is just to provide some context around what we're going to talk about in terms of the major substantive rule and the proposed changes. So when when Public Law Chapter 470 passed, it requires the MHDO to collect data from prescription drug manufacturers, wholesale drug distributors, and pharmacy benefit managers. And we were required to create an initial rule through routine technical rulemaking, which Colleen just went through with you. So the first year, we created a rule. My board adopted a rule through the routine technical process, and that was adopted earlier last year. It's hard to believe, early 2020. And this is brand new. MHDO has collected pharmacy data for a very long time from payers. So we collect data once a pharmacy claim is paid. But what we haven't collected is data from manufacturers, wholesale distributors, and pharmacy benefit managers directly. So brand new to us. And we put together a rule with a lot of input from various players in the system, as well as I hired an expert in this field to help us. And what we realized once that rule went into effect is that we could have done a better job with clarifying some of the definitions, some of what we understood we were doing, but the words weren't necessarily as descriptive as they should have been. And we also had heard from the reporting entities, and we'll refer to this group of folks as reporting entities, the manufacturers, wholesale drug distributors, and the PBMs. I'll refer to them as reporting entities. They had really provided feedback in terms of a lot of these changes and had said that what was really important to them was predictability. So they needed to know, were we going to be asking for information on thousands of drugs, on hundreds of, like, where was the predictability around what they could expect? And that was all to, assist with administrative burden. So I share this with you because it helps kind of put into context the fact that we have a rule in place. For 1 year, we've collected data from these entities, and we're in the process of finalizing a report that we will be submitting to the legislature that really, in this first report, what we're trying to do is give you a sense of, using real examples, how the money flows in the supply chain. And what I've learned is, and many of you have been dealing with this for a long time, the supply chain is complicated, and the relationships are interesting, and the exchange of money throughout the system is interesting. And if you've seen the visual, and I think I've gone over 5 minutes, but just really quickly, if you've seen the visual in the Wall Street Journal that shows like all the arrows, right? You have the manufacturer, the wholesale distributor, the pharmacy benefit manager, the pharmacy, the patient, and you see all these lines going back and forth. What we're trying to do is take that and actually show, based on our experience of collecting data from these folks, dollars that have real dollars in Maine that have flowed through that supply chain. So I'll leave it at that, and I'll switch over, if that now makes sense, to my testimony, which I think you all have a copy of. Okay, and just so I am sensitive to your time, is it 3 minutes on the testimony?
Oops, sorry, I had to find my mute button. It's not, Karen Lee. I think on a major substantive rule like this, we want to hear your testimony. So please proceed.
Okay, and Senator Sanborn, please give me the old, when it's, because there's a lot here, and I think probably much of this you might want to address in the work session.
Yeah,
so,
fair enough. Fair enough.
Okay.
I'll give you the hook if we're getting too long. All right.
Okay, thank you. All right, so again, my name is Karen Lee Harrington with the Maine Health Aid Organization, and I'm here to testify in support of LD 41. So the Maine Health Aid Organization, and I'm just going to read quickly through my testimony, it's only a few pages. The Maine Health Aid Organization is authorized by statute to collect healthcare data, including prescription drug price data. The purpose of Chapter 570 is to explain the provisions for filing prescription drug price sets from prescription drug manufacturers, wholesale drug distributors, and pharmacy benefit managers. The proposed revisions clarify these reporting requirements, which will ensure more uniform data submissions and streamline the data collection and validation process. The MHDO Board of Directors, and I'm going to refer to them as the board going forward, met on June 4th of 2020 and authorized MHDO to initiate major substantive rulemaking for Chapter 570. So in the first year, it was routine technical, and then any changes that we make to the rule going forward, it becomes major substantive. The proposed rule was publicly noticed on August 12th of 2020, and a public hearing was held on September 3rd. Public comments were received as the public hearing, at the public hearing, and by the comment period deadline of September 14th. The board met on October 1st of 2020, where they reviewed and discussed the public comments received and considered staff's recommendation regarding how to address each comment. A copy of the MHDO comment and response document is attached for your reference, as attachment A in my testimony. At the end of the process, the board unanimously voted to provisionally adopt the rule changes presented to you today. I do want to point out that the board did, we did make some recommendations to accept or incorporate some of the comments into the proposed changes. So we had a proposed rule, then we got comments, and then when we went back to the board, some of our recommendations changed based on some of the feedback that we had received, and we incorporated those into our recommendation that the board ultimately unanimously voted for. So attached to my testimony is also a description of each proposed change and the rationale for the change, and that you'll find as attachment B. So if you're just looking for a quick summary of the changes, and I'm happy to walk through that if you want to do that in here, attachment B is where you'd want to look. If you're looking for the comments that we received regarding those changes and then how we address those comments, you'd refer to attachment A. And then lastly, a copy of Rule Chapter 570 with the red line changes, or the changes identified in track changes is attachment C. And lastly, MHDO relied on a number of sources of information, excuse me, when we were drafting these changes, and you'll see those listed. I can't underscore how important our work with our consultant, Mr. Jones, has been. He has the experience and expertise. He works with a number of states across the country with their pharmacy programs, and has done a lot of work, in fact, with the state of California, who I think was one of the first states to start collecting data from manufacturers. So we've learned a lot from their experience and his experience working with that state. So this concludes the formal testimony. As I said, I'd be happy to walk through the specific changes. They're somewhat dense. I could certainly summarize what I think to be sort of the most substantive, or I'd be happy to do that at the work session. And I have asked Jim, he is listening today, and he will also be available at the work session as well.
Ms. Harrington, I want to kick us off with a question, which is, can you speak to the extent to which these rules have been altered to use a more uniform sort of set of definitions and those sorts of things in order to align with what other states are doing? Has that been part of the process?
Yeah, so I think if we, as you'll see as you go through the different changes, and actually on page 15 of my testimony is where the summary begins regarding the changes. You'll see that there are, I'm trying to get there myself. Actually, it's not on page 50, my apologies. It starts on page 20. You'll see that there's a section number 1, definitions, and you'll see the specific definitions that we are looking to revise. And I think that that some of these definitions, yes, they either align with other states, or they align with what we were being asked, or what some of the reporting entities were suggesting would help clarify in the definition. And then some of these are changes that we wanted to make to better clarify. But you'll see, if you're on page 20, you'll see the categories of definitions. And then we propose some changes under the registration and submission requirements. And this may be one.
Excuse me, Ms. Harrington. Excuse me, I just want to point out to the committee that I'm seeing these definitions on page 3 of the information that Colleen sent to us. So,
right.
So if you open the information that Colleen sent, it's page 3 and 4 through 5, 6. Yes, up through page 9. That we have some of those definitional changes in the materials sent to us. And I just want to clarify that for the committee so we can follow along.
And to the committee members, I just dropped into the chat a direct link to Ms. Harrington's testimony as submitted through our legislative website. So So if you want to follow along with her page numbers, you can find it right in that link that I dropped into the chat, and the public can access that through the committee's website on legislature.maine.gov. And then under the notice of public hearing for this bill, there's 3 items of testimony, and Ms. Harrington's is the last on that list. So again, we're in this virtual environment for the very first time dealing with this sort of multi pages of information, and it is helpful if we're all looking at the same document. So the link in the chat is to that. And the folks on YouTube won't be able to see the chat, but I just described how to get there through the legislature's website. It is linked right there. So sorry about that. Ms. Harrington, please proceed.
So the only thing I'll say there, Senator Sanborn, just you'll see if folks are looking at page 20, you'll see the definition, for example, of manufacturer, and we're adding repackager to the definition, and then we give you the justification under the change as to why we are adding or making the recommendation that that be added. So you'll see that throughout this document, what the proposed change is, and then our justification or rationale for that proposed change. And you'll see that there's different categories. So there's definitions that we're proposing have some revisions. There's some revisions around the registration and submission requirements of data. And that's probably where there's the most substantive changes. And it will be helpful, I think, as you do your work on these proposed changes to understand or to have some context in terms of what is now and what we are proposing and how that's different going forward. And the one thing, if I could just say, we've said this all along. We said this during the work sessions for the law that created this, that MHDO is not in the business. My board does not support just collecting data, tons of data for the sake of collecting data. That we really want, number one, we don't have the resources to do that. And number two, we recognize the administrative burden that puts on those entities that are submitting data. The law now, as written, really limits what we can do with this information once we get it. And that's very different than our other data sets. But having said that, that's what the law is. And so what you will see in our first report, which is we are required to produce under the law, we can't talk about any specific drug or any manufacturer because of the limitations. But we can give you a sense of what's going on in the system. So our desire here, and what you'll see in these proposed changes, is to be able to really focus those drugs that we want detailed information on from the reporting entities, the manufacturers, wholesale distributors, and PBMs, to align with the other law that you guys passed a couple of years ago that requires us to report on the top 25 most costly drugs, most utilized, and the ones with the highest year-over-year increase. And we want to include those in our pool of drugs that we may be asking these reporting entities to provide information on. And the way the rule is written now, that's not clear for manufacturers. We can collect that data from the PBMs and the wholesale distributors, but for manufacturers, we're limited to those drugs that hit one of the triggers. That was never the intent, but that's the way the language in the rule is written. So that's probably the biggest substantive change that we are proposing. And one of the things that we are 100% committed to is providing those that are reporting predictability. So the other thing that we've changed, if you pass this, is we've said, okay, we're going to be very clear about the pool of drugs that we may look at and then ask the reporting entities to provide more detail on. But we are going to publicly post what drugs we want detailed information on in mid-February. And then we can't ask you for anything until 30 days from that posting. And then the reporting entities have 60 days to submit the data. So they have a total of 90 days to pull together the detailed data that we are looking for. And we are also committed to not asking for hundreds of drugs. We don't have the resources to do that. Again, we want to focus. What are the most costly? What are the most utilized drugs? We're not interested in looking at thousands of prescription drugs. And you'll hear us talk about NDCs. That might come up a lot. And when we say an NDC, that's basically a drug product. The NDC is the code that's used to identify the manufacturer, the drug, the type of dosaging, et cetera. So I know I'm going into details. I'll stop there and happy to talk about any of this in the work session.
Great. Thank you, Ms. Harrington. We do have a number of folks planning to testify today. Are there questions from the committee that should be directed at Ms. Harrington at this stage? Okay, seeing none. Thank you so much, Ms. Harrington, and I'm sure we will be checking back with you at the work session on this rule.
Sounds great.
Great. So I am working from a list of folks who signed up in advance to testify on this bill. For those listening in at home or who might be attendees, we did ask for folks to contact our clerk in advance if they wanted to testify. But if there are people who didn't get that process quite right this time because it is a new process, please do either reach out by email to Christian, our clerk, or if you're in the Zoom and you planned to testify, you can raise your hand and I will see you and we'll try and work you in. At this point, we would take, yes, the email address for Christian is hcifs@legislature.maine.gov. So you can always reach him there with these sorts of administrative glitches that might arise. And he's great at multitasking and being able to try and sort these things out. At this point, I would accept testimony from any other person in support of the rule. I don't have any on my list. I don't see any hands raised in the attendee list. So with that, I will move on to Sam Hollemeyer from PCMA, and we'll have Christian pull him in as a panelist to join us.
Good morning, everyone. Can you all hear me?
We can, Mr. Hollemeyer. Please go ahead.
Excellent. Thank you so much. Thank you, Chairwoman Sanborn, Representative Tepler, and members of the HCIFS committee. My name is Sam Hollemeyer, and I'm here today on behalf of Pharmaceutical Care Management Association, otherwise known as PCMA, who represents pharmacy benefit managers, which I'll refer to as PBMs throughout my testimony. I want to thank you all again this morning for allowing me to testify in opposition of LD 41. I will distribute this testimony, I guess, electronically or submit electronically after the meeting, so I will be happy to follow up with that. Again, I'm here to represent the PBMs, which manage prescription drug benefits for large employers, health insurance carriers, labor trusts, and government programs, as well as other payers. I appreciate the opportunity to provide public comment on LD 41 and reporting instructions. We, however, remain concerned with some of the current proposals and rulemaking language within LD 41, and I'm going to outline my comments right now. So on the PBM reporting requirement, it is on the page 8 of the report that was sent out. It's the circled page 8, not the page 11. Again, this is the PBM reporting data set. So the data request in the rulemaking is expanded to include the entire United States. We strongly believe that any data collection should be limited to just the state of Maine. The MHDO only has the right to data based on utilization of drugs in Maine, as the MHDO is clearly charged with the law of providing greater consumer awareness of factors contributing to the cost of prescription drugs in the state. Therefore, the requirement to broaden the data required beyond the borders of Maine, we think goes beyond that scope. Additionally, Ms. Harrington from MHDO mentioned a law that was passed on the top 25 drugs and reporting requirements there. I went ahead and looked back at that law, and those 25 drugs that we are required to report on, or the state collects data on, is specific to the state of Maine and not the entire United States. So again, I just want to reiterate that we want to limit the scope to the state of Maine and not the entire United States. The other concern I want to outline is the notice date in which MHDO will notify the PBM has been charged to an earlier time in the year. When this rulemaking came out, it was April, and then it was scaled back to an earlier time in the year. We request that it be kept to April, as there can be a lag in reporting on reconciliation between the PBMs and manufacturers. The concern we have with moving it to an earlier date in the year is that this information is crucial to be included in the report, and the suggested new timeline could result in inaccurate information that we provide to the MHDL. It's these reasons that I just outlined that we remain concerned with some of the rulemaking language in Chapter 570 that's tied to LD 41. I want to thank you so much for allowing me the opportunity, and this is my first official legislative virtual testimony, so I would be happy to take any questions at this time.
Thank you, Mr. Hallmeyer. The technology seems to be working.
Excellent.
Are there any questions from the committee? Representative Tepler.
Thank you, Madam Chair, and thank you, Mr. Hallmeyer, for being here. Can you tell me whether or not the concerns that you have were presented to the MHDO during the comment period?
Yes, ma'am. PCMA did participate. We submitted comments and then participated in the public hearing back this summer and early fall. Yes, we did participate and shared these concerns.
And what was the response from MHDO regarding your particular concerns?
Yeah, regarding to the United States portion, so the first concern I mentioned, and I'll reiterate, it's to collect data throughout the whole United States versus just the state of Maine. It isn't. They did provide a comment in the printout that was sent, basically saying that they want to keep it uniform amongst this report that they currently have that's being suggested with the rulemaking. So other reporting entities, it's required throughout the entire U.S. So they stuck with that uniform the entire U.S. throughout this report, and that was the justification.
Thank you. Appreciate that.
Are there additional questions from the committee? Representative Morris.
Yes, thank you, Madam Chair. Mr. Hallmeyer, could you, on your comment relating to the collection of data from the United States versus Maine, could you just sort of, I'm trying to flesh out better your concerns there. Is it that there is, do you see it as there being a benefit to Maine consumers if we collect that data nationally, or is it just an inconvenience for you guys? I mean, what is the exact, I'm just trying to get to the heart of what the exact issue is.
Sure. So again, the state is looking at drug prescription data in the state of Maine to lower costs for the state of Maine, people who live there, yet they're not collecting data on prescription drugs in the state of Maine, rather the entire United States. So the reason I'm bringing this up is we're looking to solve prescription drug prices in the state of Maine, yet we're not collecting data in the state of Maine. That's the reason we bring up this concern.
Okay, thank you. Additional questions from the committee? All right. Seeing none, thank you for your testimony, Mr. Hallmeyer. We would now take any additional folks who wanted to provide testimony in opposition to the rule. And I don't have any others on my list, and I don't see anyone in the queue raising hands. I'm not seeing any urgent text messages. So with that, we'll move on to neither for nor against, and I will call on Ann Robinson, representing Pharma. And Christian, if you could pull her in, that would be great. Ms. Robinson, if you'd like to unmute yourself and turn on your camera, you have the floor.
Thank you, Senator Sanborn, Representative Tepler, members of the committee, Ann Robinson, on behalf of Pharmaceutical Research and Manufacturers of America. Actually, at this point, we really don't have anything more to add beyond what we had provided to MHDO in our written comments, which we now recognize the committee has in front of it. So we don't necessarily need to take any more time, but we would like to be available at the work session or able to participate in the work session.
Great, thank you, Ms. Robinson. Does that go for Mr. Doherty as well, or was he planning to testify separately?
No, it does go for him as well.
Okay, fabulous, great. Thanks so much, and we appreciate you relying on the written comments. The next person that I have to testify neither for nor against is Ashley Van Meter from the Association for Accessible Medicines. And
here I am.
There she is. Excellent. Welcome. The floor is yours, Ms. Van Meter.
Okay, my name is Ashley Van Meter. I'm from the Association for Accessible Medicines. We represent the nation's leading manufacturers of generics and biosimilar medications. We have had a back and forth in dealing with Karen Lee Harrington from Maine Health Data Organization and provided some information from some of our members about particular portions of the actual rule, specifically the inclusion of a drug product family definition and all references of it within the proposed rule. The conversation and the comments that we had submitted previously, we feel that during the process of the underlying legislation, and we worked with Senator Vitale and also the committee on the underlying legislation, was that if you tripped one of the triggers in the statute, or if you were in the top 25 of the previous statute, those were the underlying triggers for the statute that you would then have to report certain pricing information and give the data that was asked for by Maine Health Data. With the inclusion of the definition, we had manufacturers that did not trip or violate the statute at all, getting notices that because someone else had done that, they were required to report this confidential and proprietary information. And so they complied with everything. They did not raise their prices in any fashion that would have tripped these triggers. However, they were required to go, in some cases, to as many as 15 different departments within their company to provide the data that was requested by Maine Health Data Organization. Leading up to this, in working with the folks at Maine Health Data Organization, they did issue retraction notices for that information for them up until this point. But moving forward, we would just say that the rule should be adopted contingent upon removing the portion of the definition that refers to drug product family and strike all references to that, because having negotiated with the other parties and as well as working with Senator Vitale and the committee, it was never, we believe it was never intended to include that if one product in a product class or family violates the statute, trips these triggers, that then all of the folks in that product class would then have the burden of reporting. If you can imagine companies that feel that they've complied with the statute, all of a sudden receiving notices saying that because of the fault of someone else in the product family doing something that violates the statute, trip these triggers, now all of a sudden have to go through this onerous process of providing this confidential data. It doesn't provide for a consistent approach to business practices for many of our members. And so we just wanted to work further with the committee through the process of the work sessions, moving forward with Maine Health Data to potentially strip those particular references to the drug product family within the rule, and then we would be fine with the adoption of the rule.
Thank you for your testimony, Ms. Van Meter. I have a question with regard to drug product families, or just, I guess I'm needing some clarification. I guess here's how I'll phrase it. Can you let me know if I understand this correctly or not, that what you're saying is that some of your members manufacture drugs that are part of what would be considered a drug product family, where some other manufacturer manufactures other members of the family and had a price increase. Is that an accurate way of kind of framing that?
Yes.
Okay, so it might be possible for us to change the definition of drug product families to simply like eliminate that possibility by making clear that we mean drug product families manufactured by the same manufacturer.
I think if it would be by the same manufacturer, so long as it's not a different drug that happens to be within that group that did nothing, did not raise, did not trip the triggers or anything like that, so that it's solely focused on the drug, the particular drug and manufacturer that actually violated or tripped these triggers.
Okay, I think though that when we talk about drug product families, it's an attempt to make sure that there haven't been just slight changes in dosing or slight changes in delivery method in order to hide price changes. So I think that's what drug price families is meant, or drug product families is meant to capture. And so I would definitely look for additional work from you, if you do want us to change this definition, to figure out how we could still get at that particular issue, which I think is a real issue of hiding or misleading data sets based on slight changes in product name or product formulation in some way or shape or form in order to hide the ball on price changes. So I understand what you're saying if it's a completely separate manufacturer, but if it's not, I really am pretty skeptical. So with that feedback, I would definitely welcome you in the time between now and the work session to give that some more thought and see if you can be helpful to the committee with that regard.
I definitely, and that is exactly what did happen. It was a different manufacturer that tripped those triggers, and 3 of our members were asked to provide data since that happened.
Okay, so that seems like an issue we could address. The broader concept of, drug families is an important concept, however, I think. So, so let's try and figure out a way through that. Representative Tepler, did you want to ask a question?
I had basically the same question and was looking for perhaps a specific example to help expand that concept. If we could talk about a particular drug family and some iterations of that drug family so that we could have a more clear understanding, but that can be for the work session.
Okay.
I think that you've answered some of Senator Sanborn's concerns that were also my concerns. And so I would like, though, to have a specific example for the work session.
Okay, we definitely can work with our members to give it. And like I said, we did work with Maine Health Data Organization. And when it did happen, it was, those notices were retracted and they didn't have to provide it in the long run. But with the way the rule is now, that type of thing will happen again in the future.
Okay, great. Is there anyone else who has a question for Ms. Van Meter? All right, seeing none. Thank you so much for your testimony. I do not have anyone else on the list to testify today. If you feel you were inadvertently left off of the list to testify, please raise your hand, send an email to hcifs@legislature.maine.gov, text me, or whatever sort of thing you might be able to do in order to let us know within the next minute or so before I close the hearing. You are always welcome to submit written testimony through the legislature's website. There's a link to submit written testimony on our committee page, just at the top right-hand side of the committee. page, you will see where it says testimony submission. And now I have vamped long enough and seen no one attempt to be recognized. And so with that, I will close the hearing on LD 41 and thank those folks for providing that information to us this morning. Okay. So our next order of business that we would like to proceed with is to open a work session on the supplemental budget items that we heard yesterday during our joint hearing with the AFA committee. And so Colleen, so with that, I'll open that work session and ask Colleen to give us her analysis.
Thank you. As I think most of you were present at yesterday's public hearing with the Appropriations Committee. I'll briefly, I'll share my screen here. And show you, hopefully everybody can see, these are the documents that give the background for the two items that are within the HCIFS committee's jurisdiction with regard to the proposals included in the supplemental budget. And yesterday you had the opportunity to hear from both the Commissioner of the Department of Administrative and Financial Services, Kirsten Figueroa, and Karen Lee Harrington spoke about the initiatives with regard to the Maine Quality Forum. And you were able to hear their overview of what those proposals are with regard to de-appropriations as part of the supplemental budget to reflect previous action that was taken through curtailments by financial order. So the supplemental budget will sort of formally recognize those curtailments as de-appropriations in order to meet the financial needs and budgetary needs of the state. The Appropriations Committee does ask each policy committee to provide recommendations back to them in writing with regard to the policy areas, with regard to their policy areas. So they have asked at the HCIFS committee to report back to them in writing. February 5th is the deadline that they have asked us to report. But Senator Sanborn and Representative Tepler thought that it would be worthwhile for the committee to have your initial discussion and maybe even finish up with your recommendations on the supplemental budget provisions today. So the first page, hopefully everybody can see it, is the change with regard to what's called the Accident, Sickness, and Health Insurance Fund within the Department of Administrative and Financial Services. And this is a fund that supports the administration of the Office of Employee Health and Benefits, which administers the state employee health insurance plan. And so the initiative within this program is to reduce funding by freezing one vacant part-time accountant position. And again, it reflects action that was previously taken through financial order. So it would be a proposed reduction in funding to the general fund of a little under $17,000. I think, does it make sense to go one by one or to go through all of them? I'm happy to go to the.
Sure. Let's go one by one, and I'll just ask the committee if anyone has questions for Colleen or comments on this section of the supplemental. And you can use the raise hand function rather than raising your hand, because I can't see all the boxes when Colleen is screen sharing, but I can see if you use the function. All right, I don't see anyone's hand raised, Colleen, so I think you can go on.
Okay, great. So I'll go on to the next page are the provisions within the Dirigo Health Fund. And this is the name of the fund for budgetary purposes. but all of these initiatives relate to the Maine Quality Forum, as Ms. Harrington explained yesterday. The Maine Quality Forum is a program within the state that is working towards the collection of data and initiatives to improve healthcare quality. And so I believe there are 4 initiatives within this program to make reductions to their budget. And again, all of these reductions were previously reflected through the curtailments in the financial order. And again, this is just recognizing them and making the formal deappropriation as part of the budget process. But you'll see the first one relates to managing their rent expenditures for the remainder of the fiscal year. And you heard Ms. Harrington explain yesterday that they currently share space with the Maine Health Data Organization. And for the remainder of this year, the Maine Health Data Organization has agreed to take over the responsibility for paying these expenditures. So the share of the rent that was allocated to the Maine Quality Forum will be reduced, and that's a reduction of $8,500. The second initiative reflects deferring some planned contracts for services related to validating external data related to the collection of hospital healthcare associated infections that the MHDO does pursuant to one of their rules. This doesn't eliminate their responsibility to do the external validation of data. As I understand it, it just changes the timing of that. And there's a reflected reduction in the budgeted amounts, and that's a little under $57,000 a year for the remainder of the fiscal year. The third one is a reduction that reflects projected expenditures for out-of-state travel. And as you can imagine, as a result of the pandemic, those budgeted amounts have not needed to be expended. So there's a reduction of a little more than $25,000 related to out-of-state travel. And then the last initiative is a reduction in funding that reflects a deferral of planned updates and maintenance to the Compare Maine website. And that's $26,000. And again, they're just moving the timing of when those updates will happen, as Ms. Harrington explained yesterday. And then the total reduction for all 4 of these individual initiatives to reduce funding is a little more than $117,000 for the remainder of the fiscal year. I'm going to stop sharing. I can go back to sharing if you need me to quickly. But if the committee wants to have a discussion, and then the Appropriations Committee does ask that when we do report back to them, that we do note for them the vote of straw vote that the committee does take. So they do want to see that and have that reflected in any written materials that we send back to them. So if you do feel comfortable making a recommendation today back to them, I would recommend that you do it through a straw vote.
Great. Thanks, Colleen. Representative Tepler.
Thank you, Madam Chair. I want to say that I am comfortable with these changes and recommendations, the curtailments as they have already pretty much occurred. I, however, want to just put one caveat in, and that is I am concerned going forward about the hospital infections issue. I know that right now is not a good time for the people who investigate that to be in the hospitals. However, there have been some recent articles about an uptick in hospital-related infections, And so I guess I hope that going forward, we will continue that program because I think it's an important one. So I just want to put that comment out there, but I am in support. And if the committee is ready, I am willing to make a motion when the chair indicates it's necessary.
Excellent. Yeah, I think we heard from Ms. Harrington yesterday that, you know, that work wasn't going away by any means, but that there was an appropriate curtailment or timing delay on it right now. Senator Stewart.
Thank you, Madam Chair. And I would echo Representative Tepler's remarks. I think at this point, I think we're, at least from my perspective on our side of things, I think we're in a pretty good spot for now, and we can pick up sort of the long-term discussion as we get to the biennial budget conversations as well in not too long a period of time.
No, it's coming right up. Before we get to the vote, I will give Representative Bleier an option to introduce himself. I don't think he was here when we did introductions earlier.
Thank you, Madam Chair. My name is Representative Mark Bleier. I represent District 22, which is Leamington and part of Buxton, Standish, and Limerick.
Thanks, Representative. Okay, any other comments from members of the committee? All right, so seeing none, I invite Representative Tepler to make a motion.
I move that we approve the portion of the supplemental budget that contains curtailments relating to matters that HCIFS oversees.
Okay, is there a second? Senator Stewart? That's his second.
Yeah.
Great. I like it. I like it. A digital second. I think it's fair for us, although Christian, please let us know if you disagree on a straw vote like this, if we just raise our hands in the box. So if the committee is ready for the vote, all those in favor of the motion to approve the supplemental, please raise your hand in the box and keep it up.
And what, Gina?
And Gina will have to vote later because she's not visible. Right. She has raised her hand, but we'll have to record her vote in the other manner because she's not visible, and it's not legal under our rules to vote when your face isn't visible. So we'll get her vote recorded in the other manners that it's possible to do so.
Yes, that's fine. Thank you.
Okay, great.
Great.
So that was unanimous of the members who were voting.
That's right.
And we'll follow up with Representative Melorano. And we had one member not present, just Senator Brenner. Or am I doing my quick count? Is that right?
I think that's right.
Yeah.
Does that look right to you, Representative Tepler?
I think so. I'm just counting boxes here.
Yep.
A quick question.
Yep.
I can mark Senator Brenner absent, but then how should I proceed with Representative Melorano?
She would be marked absent too. Yeah.
Thank you.
For the purposes of voting, but we'll circle back.
Yeah.
She can also, I think, vote live on Zoom later when we reconvene. I saw that procedure done on the judiciary meeting recently, and Senator Brenner is going to be returning as well. So we can do that once we've got them both on camera a little bit later on.
Yes, you can do that. So thank you. Yep. And so what I will do is I'll follow up with a written draft response back to the Appropriations Committee that the committee can review. I'll note Representative Tepler's comment as part of the committee's report back, and the committee will have an opportunity to review that before it is sent to the Appropriations Committee in advance of their February 5th deadline.
Great. Okay, so with that, we have completed our work on the supplemental budget. And let me just kind of give the committee a sense of where I think we're headed today, which is that we do have 3 bills that are available for us to work today. LD5, LD6, and LD50, 51. Is it 51? Yes, 51, which we heard earlier this week. My plan is that we'll open a work session now on LD5, but not have the intention to vote on it prior to us taking a lunch break. And that we would then reconvene and see where we are with regard to completing work sessions on LD6 and LD51 this afternoon. So that's sort of my process. That should give everyone a chance to reconvene in a caucus over lunch if desired, and give us a chance to try out this work session format as we proceed here without rushing anything. So with that, I would like to open a work session on LD5 and invite Colleen to present her analysis for us.
Okay. So thank you, everybody. I'm trying something a little different this time around since we're in this Zoom world. Normally, I would be presenting to you my analysis sort of in a Word document. I played around with things and sort of worked with trying to present it in slide form just to try to make it visually easier for you to all to see. But as we move forward today or in the other work sessions, if I'm open to any feedback if this works or doesn't work, or how it will work for the committee moving forward. For those members who were on the committee before, if you sort of prefer the old format, we can do that too. It just seems to me somewhat that screen sharing a Word document doesn't work as well as maybe presenting it in this sort of slide form. So I tried to sort of adapt the old way we did things to slides. So hopefully everybody can see what I've shared. This is LD 5. We had the public hearing on Tuesday. This is an act concerning the reporting of healthcare information or records to the Emergency Medical Services Board. The bill allows the Department of Public Safety, the Maine Emergency Medical Services Board to request and collect healthcare information or records, including information that may identify a patient. It would require hospitals and physicians, upon request by the board, to provide certain healthcare information or records to them for the purposes of allowing the board to monitor and improve the provision of emergency medical services and health outcomes. They are allowed under the bill as drafted to provide healthcare information or records concerning individuals that have received emergency medical treatment, except that the bill does provide an exception for the reporting of information related to HIV or AIDS status or testing, or records that relate to the referral, treatment, or services for behavioral or mental health disorder or substance use disorder that would identify a patient in recognition sort of the heightened sensitivity of that type of information. The bill does provide that the information reported to the EMS board would be confidential and would have some parameters around which they could share that information. They would be required to protect personally identifiable information about a particular patient. Information could be collected and shared only in sort of aggregate anonymized form. The bill also requires the board to adopt routine technical rules related to any quality initiatives adopted by the rule that would target certain information that they would like to collect and have and be reported. The rule also is required to address the authorization and revocation for hospitals and physicians to allow the sharing of their healthcare information and records to the board through their participation in the state designated statewide health information exchange. And you heard at the public hearing that that's called Health InfoNet. And the rules are also required to provide some guidelines for tracking the healthcare information and records provided by, that would be provided by Health InfoNet to the board. Some of the things to for the committee to think about as
Colleen,
yes,
Colleen,
yeah.
can I ask you to blow up your screen a little bit? We're seeing a lot
Sure.
of the edge and the top and stuff, so we don't. I am having a little bit of a hard time
Okay,
reading
yeah,
it.
see, it's blown up here, but I don't know what you see. How's that? Or should I
Yeah,
go?
that's
Is that
better. Yeah, that's
Okay.
better. Yeah.
Okay, sorry about that. Yeah, please stop me if I'm trying to present it the best way possible. So as you sort of begin your thinking about LD5 and start your discussions, one of the things to remind you about, and you did hear about this at the public hearing, is that the bill was considered last session by the HCIFS committee in the 129th legislature. It was presented at that time as LD 1996. The bill was voted out to pass as amended by the committee. It was unanimous recommendation of the committee at that time. However, the bill was not taken up in any special session before termination of the 129th legislature because of the suspension of legislative activities due to the pandemic. So it was not fully vetted and considered by the legislature. So the Maine EMS board reintroduced the bill this session, and it's before you as LD5. I would say that the language in LD5 does reflect a sort of a stakeholder process that was directed by the committee last session that asked the Maine EMS board to work with various stakeholders to help develop some language that was then adopted by the committee and included in the committee amendment last session. And that language is what's reflected in LD5. One of the things that I mentioned is that there are provisions in the bill for the EMS board to maintain as confidential information that's been provided to them if it identifies or permits the identification of a patient or a member of a patient's family. So sections 2 and 3 of the bill include the sort of confidentiality protections. There is a state law in Title I in the Freedom of Access Act that requires any legislation proposing a new public records exception to be reviewed by the Judiciary Committee. For members who have served on the HCIFS committee before, you'll be familiar with this process. But if the committee moves forward with a proposal and makes a favorable recommendation on a piece of legislation that includes a confidentiality exception, that language must be referred to the Judiciary Committee for further review. The Judiciary Committee did review the language included in LD5 that was in the previous bill last session and did recommend no change. So that's something to keep in mind if the committee does move forward. Hopefully the expectation would be that the Judiciary Committee would make the same recommendation since the language has not made, there have been no substantive changes in the language. There were some concerns that were raised at the public hearing by the Maine Medical Association related to the potential added costs and administrative burden associated with these reporting requirements in the bill, particularly with regard to independent physician practices that may not report their information or belong to Health InfoNet. And they suggested that the committee might consider amending the bill further to exempt those independent physician practices from the language in the bill. I would note that the bill does direct Maine EMS to determine the process for physicians to report that do not authorize or utilize Maine Health InfoNet. So there would be some further opportunity to develop some guidelines for that reporting as part of the rulemaking. But if the committee is interested in pursuing an exemption, I think it would be better for the committee to do that right in the statute rather than leaving that up to the rulemaking process. And Mr. Moran from the Maine Medical Association did follow up with some additional information for the committee through email today. And I did forward some information from Maine Health InfoNet with regard to some of the questions that the committee members asked at the public hearing. As I mentioned, the language as drafted does provide a reference that would give an extra layer of protection, if you will, to information identifying a patient that includes HIV or AIDS status, or that relates to the treatment or services for behavioral or mental health disorder or substance use disorder. And there are other areas of state law that recognize added protections for disclosure of records related to both victims of domestic violence and abortion or miscarriage data that might identify a patient. So the committee might consider adding language to the exception that would refer to records also that might identify a patient related to domestic violence or abortion or miscarriage data. And we can talk further if the committee is interested. I can show you where that language might be inserted as an amendment to the original bill, LD5. And as I mentioned before, the bill does direct Maine EMS to conduct rulemaking to implement the requirements of the bill. So one of the things that the committee might consider, the bill as drafted does not sort of provide any parameters for when that rulemaking must happen in terms of a timeline. That has been done in the past in other legislation that, regarding rulemaking for agencies. The committee might direct, if they want an agency to adopt rules, they might set a guardrail that, rules must be adopted by a certain date. The committee might consider adding that as a specific timeline for adoption of the rules. Alternatively, the committee could consider adding an emergency preamble and an emergency clause so that the bill, if it's enacted, would become effective once signed by the governor. The general rule for legislation that's adopted during a legislative session in terms of its effective date is that it becomes effective 90 days after adjournment of the legislative session, unless there's an emergency put on the bill. So, following the sort of general expectation for adjournment of a first regular session, the effective date of this legislation, if it moved forward, would be sometime in the fall. So the rulemaking wouldn't be statutorily authorized to begin until that date. So if the committee was interested in having that happen sooner, emergency legislation might be something that you may want to consider. I would also note that you did have some written testimony that came in through the portal from individuals that did not testify at the hearing, and I just noted those entities for you. Both the Maine Ambulance Association and the Maine Hospital Association did submit written testimony on LD5, but they were unable to provide that testimony at the public hearing. And then the last thing I'd note for you relates to the fiscal information that we've received from the Office of Fiscal and Program Review. We don't yet have any information specific to LD5, although I think you probably received an email or two yesterday from Christian about information that has come in on the other two bills that we may consider in work session today. But with regard to LD5, while we don't have specific information on the bill this year, last year's bill, LD 1996, the fiscal information for that bill indicated that any additional costs to the board associated with the added rulemaking responsibilities could be absorbed within their existing resources. So my expectation would be if the language of LD5 moves forward, you would see a similar fiscal information for this bill. I will stop there. I'm happy to answer any questions. I think I'll stop sharing too, but if you want to go back to anything in the analysis or look at the bill itself, I can pull the screen back up.
Thank you, Colleen. Okay, so I am going to open it up for questions from the committee. for Colleen to start. If you have a question for Colleen. Senator Stewart.
Thank you, Madam Chair. In reviewing the testimony from the Maine Hospital Association, and Colleen, maybe you can help me sort of summarize the gist here, that it looks like they need some clarity in the bill on how to remit the records to EMS, whether it's going to go through Health InfoNet or directly. Is that
Senator Stewart, I think that their conclusion is that we fixed all those issues with our parameters on the rulemaking last year.
Okay.
In response to their concerns last year. So as long as we keep the bill as it is with the rulemaking parameters that are in there, they're happy with it. So I think that was the upshot of what Mr. Austin wrote to us. But I agree, you have to read carefully to get to that point. Colleen, do you have anything to add?
Yeah, no, I think that's right. I think they were a part of the sort of stakeholder group, and the language in the bill and the language related to the rulemaking process and what EMS would have to do as part of the rulemaking process addressed in part those concerns that the Maine Hospital Association raised. And I think my understanding of the testimony was that they were comfortable with the bill as drafted, but if the committee made any further changes, they would want the opportunity to provide comments and back to you if the committee changed the bill, further. So,
yeah, Representative Connor.
Yes, thank you, Madam Chair. It's like drinking from a fire hydrant for me. I'm new to all of this, so please forgive me. In reading through the bill, I just want to make sure I understand it correctly. If I go to an emergency room by an ambulance, and that ambulance provider then requests information from the hospital, are they only requesting information specific to the reason I went on that ambulance, or are they requesting all of my records and now they have access to everything, or is it just information pertinent to that ambulatory visit?
Colleen, do you want to try and help with that? You're on mute.
Back.
Oh, no, you're not.
Am I good? Okay. So two things I would say to that. One is the language of the statute does provide parameters for the type of information that Maine EMS can request. They may request and collect healthcare information concerning individuals who have received emergency medical treatment within the state for the purpose of monitoring and improving the provision of emergency medical services. So they are limited in, somewhat in the type of information that they are requesting. You have also heard from Maine EMS about the type of information that they are going to be asking for. And then the second piece of it is there is a provision on page 2 of the bill that provides additional parameters to Maine EMS. So they, as part of which says that when requesting the healthcare information or records pursuant to this section or any rules that the board would adopt, the board shall request only the minimum amount of information or number of records necessary to fulfill the purposes of this section. So that is a limitation that they are, directed to only request the information that they need related to those purposes. So it's related to the emergency medical treatment that they received and to their specific purposes as well. So for instance, my understanding is how this might work is they talked about information about cardiac arrest. So if a patient was provided emergency medical treatment related to a cardiac arrest, they could request information from the hospital or the physician sort of about the outcome of the treatment of that patient, but only for that purpose. So that's how I would read those sort of two things play into limiting or determining the scope of the information that they would be asking for.
Okay. Thank you very much. I appreciate it. Thank you, Madam Chair.
Representative Evans, I saw your hand next. Go ahead.
Thank you, Madam Chair. Colleen, I just want to clarify that the main portal for communications is Health Infonet.
Yes, I mean, that's the process that the bill as drafted would envision, that the hospital and physician, the language allows that if they are a participant in Health Infonet, that they can satisfy any of the board's requests for information by authorizing Maine EMS to get that information directly from Health Infonet. If there are circumstances where a hospital or a physician would not provide that authorization, then Maine EMS would have to use a process to get that information directly. But again, the process for that in the language in the bill would require that they undergo rulemaking to determine how that would happen.
Okay, thank you.
Representative Tepler.
Thank you, Madam Chair. And I also want to draw the committee's attention to the chat where Mr. Hurley provided us with some more information regarding privacy. But I also think, and perhaps Colleen can do this for us, that we got a much better picture of what EMS was after when we went through the process for LD 1996 than we have with this repeat of the bill. And so perhaps, Colleen, you could remind the committee of what the reasoning that EMS gave for this whole issue was, and how they presented it to us in regards to LD 1996.
Sure. And I think in Mr. Hurley's testimony too that you received from Maine EMS, he also sort of reiterated some of the purpose of why they're asking for this legislation to be adopted. I think, primarily while the bill as drafted, relates to all, arguably to the provision of emergency medical services in all areas, one of the particular interests that Maine EMS has is the ability to participate in sort of a national registry, as I understand it, or a national program related to the collection of data and the analysis of data related to cardiac arrest, particularly, and heart issues, and improving the quality and outcomes for EMS treatment for those services. Mr. Hurley also talked about the ability to track information related to strokes and other particular things. But I think the primary interest, as I recall, and from both his testimony this session and last session, is their ability. Initially, I think the focus is going to be on in the cardiac and heart areas.
Thank you, Colleen. And I did want to mention that we are discouraging, and I should have said this at the beginning of the work session, but we are discouraging folks from using the chat for anything other than an administrative process. So I want to tell folks at home who might be watching on YouTube and don't have access to the chat what Mr. Hurley's comment said for the record. Because it's actually not all that substantive. It directed the committee to a particular portion of the bill. So he directed the committee to section 96.1 in the bill, which is on page 1 of the bill, starting at line 26. And his comment simply says it restricts it to that emergency medical treatment. So that was Mr. Hurley's comment for us, but I will kind of add back into my script more of a note that, we can use the chat for links so that members of the committee can quickly access testimony or a website that someone might be referencing. But that other than that, we would ask everyone to refrain from using the chat for any kind of substance. Yeah, that way, because the chat is not part of the YouTube broadcast, it's not something that we want to have any secrets, and we want to make sure everybody has that same information. So that's why I've read that into the record, and would just ask that attendees and panelists alike refrain from using the chat other than as they dictate something, like I've done in the past, like I am now dropping into the chat a link which can be found, in X location, and then that's very clear what we're sharing, and similar kind of administrative problems. Senator Stewart, go ahead.
Thanks, Madam Chair. So in looking at the bill, I don't really have a lot of issues with the way that it's written right now. The one question I think I did ask during the public hearing was the amount of instances we would be talking about. And I think this gets to the point that MMA was trying to make in regards to private practice docs. And further in noting that particular section, the requests in regards to emergency medical treatment, I can't imagine that a lot of these, essentially what we're talking about is EMS service calls, right? Like you're getting a ride in an ambulance from point A to point B because you need medical assistance. And so in those instances, you're probably not going to a private practice. I can't imagine very many instances where that would be the place. You're going to a hospital, to the emergency room, something along those lines. So I guess the question and then just a statement is, one, did we get any additional feedback between then and now as to the possible amount of instances such as those? And if not, I'm ready to move forward with what we've got.
Yeah, so Colleen did receive quite a great amount of information, actually, and a good overview from Health InfoNet. I think in the interest of time, I don't want to go through that unless there's committee members who really want us to walk through the basics of Health InfoNet on this work session. But what I really would encourage our committee members to do is to go through that information that Colleen provided. I think it doesn't, Senator Stewart, totally answer the question of, how many times would an EMS encounter, sort of fall under this purview and then require some sort of submission from an independent practice. But I think logically, all of us were in the same place in thinking through the sort of the logistics and the likelihood of that coming to pass. And then I think the other piece is the rulemaking, right? Which is how we dealt with these objections, I think, last time around to the bill, which was to say there's going to be a rulemaking process. Independent physicians who don't participate in Health InfoNet can make comments at the rulemaking process to limit the administrative burden on them and ensure that there's not sort of a standing order to present, to give every single possible piece of data over to EMS at all times, right? That would be something that probably wouldn't be able to make its way through the rulemaking process because it would be so objected to. So that was sort of my sense of the matter. Happy to hear from other committee members who have comments or thoughts at this point. All right, I don't see any additional comments. Representative Arford, go ahead. You're on mute.
Checking in to make sure the material we got that was submitted by the AMA, was that was regarding the bill this time around, not the previous in the 129th. Is that correct?
It was. The testimony that Mr. Moran provided was an objection to this version. The testimony that the Hospital Association provided sort of suggested that if we changed it from this version, there would be more concern, but they were happy with this version. That's sort of my understanding of where we stand on
I'm
that.
sorry, I'm talking about the Maine Medical Association. I'm getting my A's and my M's mixed up. I'm talking about the Maine Medical Association that was
Yep,
submitted.
Mr. Moran testified live and submitted written testimony, and that was in relation to this year's bill. Does that answer your question, Representative?
The point I'm about to make is the question I have is the testimony that they were able to provide, or at least the responses from the independent practices. They had 3 responses and they all shared that it would be a significant burden for them to have to participate in submitting this data because they were not members of Health InfoNet. I'm just wondering where that fits in this conversation at this point.
Yep. So Senator Stewart, do you want to talk to that topic? Because that's what we were just talking about.
Yeah, that was pretty much the dialogue we just had, is that if you call 911 and an EMS arrives at wherever you are, it is highly unlikely that they are going to be taking you to a private practice. They're in all likelihood going to be taking you to a hospital, probably an emergency department for whatever services that you may need at that point, or it could be, some other department if you're going into labor and call 911 or whatever. But the point being that these instances of when a EMS worker would take you to a private practice are few and far between. And something that I thought about just a moment ago is that we may want to know when those instances do come up, why they're coming up and what's happening there and what's going on. And so having that data, it may almost underscore why it is important to have that information more so than if you're going to the hospital as opposed to private practice. Does that make sense, Representative?
I actually was thinking more of a situation where a private practice would have a patient go into distress and call the ambulance to have the patient picked up there, and they would want that data as well. That's what I was thinking of. I mean, I know of instances where that have happened.
It's outcome data that this particular bill doesn't deal with that situation. The private practice already would be able to request that information from whomever rendered treatment, including EMS, which puts their information into Health InfoNet and provides that as part of their obligation to have medical records for the patients that they treat. So I think that's not the scenario that is covered by this particular bill. Representative Evans, you have your hand up.
Well, thank you, Madam Chair. Not to prolong this issue, the time that the private practice provider would actually be a part of the process would be in determining the outcome. So once the patient is discharged from the hospital, then they return to their private practitioner, and that's where information for follow-up
Froze. I think you froze there at the end, Representative Evans, but I think we got the gist. And I just want to kind of call the committee's attention again to the fact that we inserted rulemaking last year, to address these very issues, to ensure that the amount of information that would be requested and the frequency with which it would be requested was reasonable, and that folks would be able to comment on that process and the parameters of the types of studies that might be done prior to those going forward. So there's, oh, we lost Representative Evans. Okay. So there's 2 outstanding issues that I think we need to discuss before we can move to a conclusion on this particular bill. The first one is the breadth of the exception for personally identifiable information personally identifiable health information. And I'll just direct the committee to page 1 of the bill at line 23, if you're looking at the version on the legislature's website in PDF form. But in any case, there is a provision now, as Colleen explained, providing some additional protections for certain types of health status information, including HIV status, behavioral health, behavioral mental health disorder, substance use disorder. I would recommend that we add to those categories of data that receive heightened protections, a couple of other categories that are not generally allowed to be shared on Health InfoNet. And those include domestic violence, abortion, and miscarriage. Those are items of data that, as I understand the information we got from Health InfoNet over the last couple of days, those items are occasionally reported to Health InfoNet, but if they are blocked in order to maintain patient privacy. And so I think we would want to, I would like to propose that we amend that section of the bill to slightly broaden the language to better track the types of health information that are blocked from Health InfoNet due to other parts of the statute, including domestic violence, abortion services, and miscarriage. So I'll just so take that item and open that up to any comments that the committee might have on that topic. All right, seeing none. The other topic that was raised by Colleen was about the timing of rulemaking and whether we wanted to make this an emergency bill in order to be able to expedite the rulemaking process. And I think that's a fair suggestion, particularly since it seems like we do have broad support amongst both parties in our committee, and could likely get this through the floor with the emergency preamble attached. And we've already delayed this for a year due to the pandemic. So I think there's a good argument for that, but would love to have feedback from the committee on that particular issue. Senator Stewart.
Thank you, Madam Chair. I've got another question.
Sure.
That was sort of brought up after the fact in regards to which records can be accessed after the fact. So, and when I went through that section 96.1 again, I guess it's unclear, and maybe we should get some clarity on whether or not, and I think this may have been MMA's issue yesterday or whenever we heard the bill, that if a patient is dropped off at a hospital, can those private records from a private practice doc be subsequently accessed because that patient is now covered under this new reporting law? And so, and I wonder if maybe that's where the rub is on the private practice side, that it's their understanding that those records would be accessible, and now they have to, even though nobody was ever dropped off there, they now have to provide those records upon request. Does that question make sense?
It does, and I think you're right. I think that's a correct reading, but I think it goes back to the purpose for which they could be requested, and the purpose for which the only purpose for which they can be requested is monitoring and improving the provision of emergency medical services and health outcomes within the state. And so, and then there's a rulemaking procedure that requires particular quality initiatives to be adopted by the board, and then those initiatives to be, communicated to providers and so forth. So I feel like, yes, that is a train of data that could be collected, but only for a limited purpose. And so again, kind of go back to the thought exercise of, you know, I think this is really about figuring out whether stroke patients are receiving the correct, you know, treatment in the ambulance. And so while it's possible that the health researcher might want to figure that out by looking all the way back to their primary care doctor or their rehabilitation procedures and so forth, really the question is, you know, what happens in the immediate aftermath, and how was the stroke treated? So my understanding is that while there is sort of a hypothetical you could spin that opens up a very large chain, that's not sort of what this bill is really angling for, and that there's a rulemaking procedure there in order to provide some guardrails. So I think that's how we got comfortable with it last session, because we did have this exact same conversation last year, and then had a stakeholder process that resulted, I think, in this rulemaking provision. I guess the other thing I would just say is that I think that the health research and quality research is going to be more easy to do with Health Info Net data and electronic medical records data anyway. So it strikes me that in the rulemaking process, it's going to be that the researchers actually want the data that's easy to digest and easy to collect, and therefore also easy to share. So I have a sense that this is all going to work pretty simpatico. But that's sort of my sense of that issue, Senator Stewart. Representative Quinn, go ahead.
Can you hear me okay?
Mm-hmm.
All right. My question is just that if a patient opts out of Health InfoNet, because I know that they can, would that opt them out of this as well then, where their information would not be accessed by an outside source without their permission? You know who would have that?
This is ridiculous.
Colleen, do you have an answer to that?
I think the answer would be yes. Particularly if the hospital or the physician authorizes the information to come from Maine Health InfoNet, they would only be able to provide the information that they have. Health InfoNet would only be able to provide the information that they have. And if they didn't have an information about a particular person because they didn't have authorization for that, then I think that would not be included.
Yeah. Senator Stewart, just thinking about your question again, I wanted to point you to page 2 of the bill at line 10. Yeah. It talks about a restriction, or it specifically says that the board shall request only the minimum amount of information or number of records necessary to fulfill the purposes of the section. So again, it kind of puts its thumb on the scale in terms of not having a blanket, you know, approach here, but a more targeted one.
Yeah, that I see that, and that puts my concern pretty much at ease. So
okay, great. So Representative Tepler.
Thank you, Madam Chair. And I just want to say that if you are being treated in a hospital or an emergency room for a cardiac arrest or a stroke and you were brought in by ambulance, chances are that the hospital will request your records from your primary care physician. And those records will be transferred to the hospital. And so when the hospital responds to any requests for Maine InfoNet information, it must include some of your primary care physician's notes regarding specifically this issue and this outcome. I don't think that the hospital doesn't access your primary care physician's records. Now, I guess if we're tracking outcomes beyond the hospital treatment, that's something else again, and that I assume will be addressed in rulemaking. And people will have the opportunity to comment on the request for information on outcomes beyond the treatment in a facility.
I think that's right, but I think we're speculating, and I think it's really, you know, the language of the statute is pretty clear that only the minimum amount of information can be requested, and then there'll be rules and parameters put around that. There was just another substantive comment dropped in the chat, which I will read into the record. So Sean Alfreds, who is in charge of Health InfoNet, tells us that if a patient opts out of Health InfoNet, the information would not be included or shared with main EMS, I think sort of by definition, which I think is what Colleen just said. Representative Evans. Oh, I'm afraid you're freezing again. So Representative Evans, could you turn off your video so that we have a better chance of hearing you, because we're not hearing you right now. Perfect.
Okay.
Thank you. Go ahead.
Now?
We can.
Okay.
Yeah, if you keep your video off, we might hear you better.
Okay, thank you. I just wanted to go back. I think we're at the process now where these questions will be managed in rulemaking.
Yes. Great. I agree.
To that Representative Tepler has mentioned, I totally agree with. And I think that the rulemaking.
Representative Evans, definitely helps if you turn your camera off when you're speaking, because you've definitely got some internet connectivity wonkiness happening today. So, all right, but I think we got the gist of what you were saying. I'm sorry that we're not hearing you as clearly as we would like to. Okay. We're going to, as I had foreshadowed, we are going to break for lunch before we take any sort of vote on this, our first, our first work session, so that we can make sure that any kinks that might have arisen can be worked out amongst our caucuses or amongst our technical support crew before we take any votes. But I want to make sure we've got everything on the table before we adjourn for a lunch break, so that we might be ready to move right along when we return, assuming things are good. Representative Arford.
Yes, thank you, Madam Chair. This is my first work session, and I want to make sure I understand your terminology. When you say we have everything on the table, does that mean if there's still questions other than the two you mentioned, that you would want to hear them now? Is that what you're referring to?
Yes. I say that with some trepidation, because we're also going to go through a process of being able to talk amongst ourselves as a caucus to answer any questions if that might be a more appropriate setting. It's sort of, but yes, if there's something else you want to see changed in the written part of the text of this bill, we should talk about it now so that everybody hears about it.
So I still have concerns about the ability to act, to require, to compel the small practices to submit data. And my question would be to our group, is there a way would we need to say anything? Would that come up in rulemaking? How they would be compelling them, if there would be a penalty if they weren't able to comply or something like that? Or can we actually put in the legislation that they certainly are welcome to request, but that there will be no penalty if the small practice is not able to comply?
So that is something that would be addressed in rulemaking, which talks about determining the frequency of reporting as well as the manner of reporting. Yeah, I mean, we've talked about that issue for sure. So I feel like that one's on the table at least. So I appreciate your making sure it's on the table. And I think it is.
Thank you.
Senator Stewart. Yeah.
Thank you, Madam Chair. I just want to be clear about sort of the overall plan for the rest of the day as well before we break for lunch, because I know some of us have to go in our different directions. So is the plan to actually vote on this and the 2 remaining bills, or just bring them up in work session, bat them around and see what we can maybe come up with and then pick them up again next week?
Yeah, so I would like to vote on LD5, Senator Stewart. And I would like to open a work session at least on LD6 and LD51 and see where we wind up. If it appears we have consensus, I would hope to vote. If it doesn't appear we have consensus, I would table, and we could return to it at a later date, probably early next week.
Okay. If that's the case, then I would like to just touch base with the other House Republicans, just as a notice to the House Republicans, don't just scatter for lunch.
Right.
Touch base real quick after this and have a quick corner caucus. Thanks.
Yeah, and my plan is that we would my folks from the Democratic Caucus will be caucusing during lunch as well. So that's our sort of plan. And Representative Morris, go ahead.
Yeah, I was just going to ask the plan as far as breaking. We're going to do the breakout for the caucuses. Have Christian put us in breakout rooms. Is that the idea?
No, no, I think that the plan for caucusing has been to rely on the partisan offices, Zoom licenses that you might have, or telephone call, whatever process you have set up for that, because webinars, which is what the format is where we are right now, do not allow for breakout rooms. So there were other options that I think have been provided for caucusing, and Senator Stewart's nodding, so that makes me feel really
that's good. No, as long as he has a plan. I just know we were able to do a breakout room for labor yesterday, so I didn't know if that was the same plan here or not. But
yeah, it's
whatever works. I'm amenable. Just want to make sure.
Okay. 2 seconds.
Okay. Thank you, Chair. Thank you.
All right. So Senator Stewart has you covered, and
awesome.
We're not going to do breakout rooms just because we're in a webinar format. And I think at least in HCIFS, we are going to use this webinar format for our work sessions because I like the concept of having folks in the committee room, quote unquote, and we've had 12 folks or 11 folks in the committee room throughout our work today. And I don't know, somehow that feels very comfortable and very virtual similarities to how we usually do our work. And so we will be using this particular format, which doesn't allow for the breakout rooms. But Senator Stewart's got you covered for lunch.
Excellent. No, I just thought I'd ask.
And that's perfect. And I think with that, unless let me check the chat here. Yep. So great. So that's everything. I think that we want to lay out before we break for lunch. Looking at the time, I think it probably makes sense for us to plan to reconvene at 1:30, which will give everybody time to both eat and caucus and digest some of what has gone on, and perhaps even check an email or something like that that we may need to accomplish before we return to our work together. So unless there's any last minute comments from anybody before we do break, I don't know, Colleen, do I need to table LD5 if we're just going to come back to it after lunch?
I don't think so. I mean,
okay.
I think we're good to just keep the work session open. I don't know.
Great.
Yeah.
as
whatever works. I mean, if you want to table it, take a
good.
show of hands, that's fine. But everybody heard you, so I think that works too.
There's no objection on this side, Madam Chair.
I think it's just a question of announcing that we're going to continue the work session after lunch.
Perfect. We will be continuing the work session after lunch. If you are not leaving this Zoom, please make sure that you have turned off your camera and your microphone. And if you would prefer, and I perhaps recommend, you can also leave the meeting and then rejoin it at 1:30. It's sort of up to you how you'd like to do that. We will continue streaming live on YouTube throughout lunch, and we will return right around 1:30. Thanks, everybody.
Kristen, are you there, Kristen? When are we going into the caucus?
Representative Arford, I think you'll get a separate, you'll get a separate Zoom link.
Okay, I just
about that.
My email is not working well, the Outlook, so I wanted to make sure I did not miss anything. Thank
Yeah.
you.
I think the chairs will do that directly, either through your phone, email, or text. Yeah.
Thank you so much.
You're welcome. See you soon.
Christian, are you able to hear me? Yeah, so I don't know why I'm not getting, I don't know if everybody's getting an email and I am not, and I have to call you daily to get on board. Kind of trying to figure that out so I don't have to do that. Is any recommendations for me?
So with yesterday with AFA, those links came from AFA. That's not something I ever touched.
Right. No, I understand. Yeah.
But so on Tuesday, were you able to access yourself, or did you call me on that day as well?
I called you on that day as well. I've called you Tuesday. I called you today.
I'll dig around. I'll look.
Okay. Thank you. Another question I'm curious about is how do I, when you see John, Representative John Connor right now, he's not live on video, but hey, he's got a picture of himself. I kind of like that feature. How do I display that on my, when I take my video camera off, a picture of me would be displayed like Representative Connor is now.
Sure. So right now, actually, if you hover over yourself, you can see there's a little mute option and then the three little dots.
Yeah, I see that.
One of the things under the three little dots, if you click on that, should be edit profile picture. And you can
Okay, I do not have that. I have mute audio, stop video, rename, pin, and hide self view.
Interesting.
Representative Blyer, if I may.
Yep.
You have to actually log into Zoom. If you just click on the link that was emailed to you, you're just in a generic Zoom meeting. So you would need to set up a profile by signing into Zoom in order to have your photo.
Got you. Okay. Thank you.
All right, as we're reassembling here, we're gonna see more and more of our folks pop in. Welcome back from lunch. It's only 1:34, which is really quite remarkable as legislative time goes. So again, maybe we'll keep this particular innovation of the COVID era where we start meetings on time when we say we're going to start them. We'll have to see how late into session that actually goes. But folks are reappearing, so that's a good sign. And just to give people a sense of where we're headed, I've got some missing folks still, but they're coming. So just to give folks a sense of where we're headed, we are going to continue. That's so strange that Rich is named Heather. I'm going to rename you Rich.
That happened this morning also when he came in, and then it shifted over. I don't know whether he changed it or
No,
Christian did.
I'm not the host at the moment, Christian, so you'll have to rename Representative Evans for us and or make me the host. All right.
I'll stop my video for the time being, but I'm here.
Okay. Oh, Representative Evans is now the co-host. You got it, Christian. You got it. Okay, perfect. Yeah, so Representative Evans is having some internet instability issues, and we've advised him that if he turns off his video, we'll be able to hear his voice better, which is really critical when he's sharing his thoughts with us. So if others are also having a similar issue with internet instability at any point, that does seem to help. And so that may happen from time to time. So again, for those watching along at home or in our virtual committee room here on the webinar, we are continuing our work session on LD5 and then planning to open a work session on LD6 and LD51 this afternoon as well. With that, I'm just trying to look and see who's made it over from our Zoom. I think we've got everybody. Representative Morris, are you guys good to go?
Yes, we are.
Perfect. Okay, so we had a pretty good lengthy discussion about LD5 prior to taking our lunch break. And just to kind of recap, we had talked about changing a couple of items in the bill. One was expanding the verbiage with regard to types of data that would be excluded from sharing, to include domestic violence records, abortion records, and miscarriage records. And we had also talked about putting in an emergency preamble so that the rulemaking could take place more quickly. And I think those were the two changes that we had discussed. I want to touch base with the committee and just see if there are any more comments before we entertain a motion. Okay, seeing none, I will entertain a motion. Representative Tepler.
Thank you, Madam Chair. I will move ought to pass as amended with the amendments that you mentioned.
Okay. Colleen, do you need any additional detail on that, or is that clear?
I'm all set.
Okay, great.
I think you just repeat, I don't want to repeat what you just said, so I think we're good.
Perfect. Is there a second? I saw Representative Connor's hand, so assuming that's a second. Yes, great. Okay.
Madam Chair, I second the motion.
Wonderful, thank you. And I think the virtual hand raise will be fine. I just want to make sure it's not for a question. So, Okay, perfect. So with that, I think this does need to be a roll call vote. So I will ask Christian to call the roll.
Just one second. I think if you could get Representative Evans on his video, then that would work for the purposes of voting, or he should be visual, I think. Yeah.
Yeah.
Thanks.
Great.
First on the roll is Representative Quint. Madam Chair, would you like to announce what the motion is?
She just joined us again. Oh, I'm sorry. I'm Madam Chair. I was thinking Colleen was going to do it. Sorry. Yeah, so the motion is ought to pass as amended. I wasn't listening carefully enough. Ought to pass as amended with the 2 amendments being the ones we discussed before the break. Representative Quint, which included the expanded language around the exclusion of certain types of private data and the emergency preamble to allow for faster rulemaking. So that's the motion on the floor, ought to pass as amended. It's been seconded, and you are the first on the roll. So
Representative Quint.
Yes.
Representative Quint, do you want me to repeat back as I go?
Sure.
Representative Quint ought to pass as amended. Representative Connor.
Yes.
Representative Connor ought to pass as amended. Representative Bleier.
Yes.
Representative Bleier ought to pass as amended. Representative Morris.
Yes.
Representative Morris ought to pass as amended. Representative Matheson.
Yes.
Representative Matheson ought to pass as amended. Representative Evans. Representative Evans.
Yes.
Representative Evans ought to pass as amended. Representative Arford.
Yes.
Representative Arford ought to pass as amended. Representative Melorano.
Yes.
Representative Melorano ought to pass as amended. Representative Brooks.
Yes.
Representative Brooks ought to pass as amended. Senator Stewart. Absent. Senator Brenner.
Yes.
Senator Brenner ought to pass as amended. Representative Tepler.
Yes.
Representative Tepler ought to pass as amended. Senator Sanborn.
Yes.
Senator Sanborn ought to pass as amended.
Okay. Great job, everybody. We got our first bill under our belts. Great. Okay. So next, I'm going to open a work session on LD6 and turn it over to Colleen for her analysis.
Sure. Thank you. Oh, let's see. Share my screen here.
And just for the committee, Colleen did send us over lunch these slides, I think.
I did.
So if you're running a second screen, as I am, and want to make it bigger, you can do so by opening it from your email.
And how does it look now? Should I try to make it bigger?
Yeah, if you could just hit that plus sign a couple times, I think that'll help.
How's that?
Yep, that's better.
And if I scroll down, that works as well for you?
It does, yep.
Okay, great. I'm gonna scroll down a little so you see the whole screen. So I'm gonna go back to the first page. Okay, great. So as Senator Sanborn said, this is the work session on LD6, which is an act to revise certain financial regulatory provisions of the Maine Insurance Code. This is a bill that was introduced by the Bureau of Insurance. Like LD5, it is a bill that was considered in the 129th legislature, but due to the delay and the suspension of the legislature's work, it was not able to be fully considered before the adjournment or the termination of the 129th legislature. The bill does a number of things, makes a number of changes to the Maine Insurance Code, but its primary purpose is to update provisions in the code and incorporate recent amendments to model laws that have been adopted by the National Association of Insurance Commissioners, which most often I'll refer to as the NAIC, and making other related technical changes. A number of the changes have to do with reinsurance and the ability of entities to provide reinsurance to insurers authorized to do business in Maine. And again, you heard at the public hearing that much of that is needed to reflect international trade agreements that have been put in place with the United States and other countries. So recognizing reinsurers that originate outside of the United States. There are provisions in the bill too that correct some, make some technical changes and eliminate some obsolete language. There's also a provision in the bill that relates to adjudicatory proceedings that are conducted by the Bureau of Insurance related to changes in control of domestic insurers. It clarifies that multi-state proceedings conducted under Maine law would be considered public proceedings to the same extent as those proceedings if they were conducted individually by the state of Maine. So it just clarifies how the how those proceedings are conducted, whether they're conducted by the individual state Maine or if Maine is part of a multi-state proceeding with regulators in other states. It clarifies when an insurer or an insurer group is required to conduct its own risk and solvency assessment. And again, the guidelines are set forth in some NAIC documents. It corrects a conflict in the statute related in the credit for reinsurance provisions. It does include a reference providing that documents that a certified reinsurer is required to file with the Bureau of Insurance would not be considered public records in Maine if they are confidential under the laws of that reinsurer's jurisdiction of domicile. So it requires that the Maine regulator would recognize and maintain that confidentiality from the laws of the other jurisdiction. It also, again, as I mentioned, would bring Maine into compliance with these bilateral, trade agreements that have been entered into by the United States, the European Union, and the United Kingdom. It does correct a drafting error that was included in the original NAIC model that was adopted in Maine, so it makes that change and also corrects some inconsistencies in the statute with regard to when health maintenance organizations are required to be examined by the Bureau of Insurance. And lastly, there are provisions related to reciprocity when Maine puts an insurer in receivership. It recognizes the reciprocal states' laws and brings Maine again into conformity with the NAIC guidelines for how receivership proceedings should move forward. So there are a number, it's quite a long bill. There are a number of technical provisions. If the committee has any questions, you'll see when I get through to the end. I'm happy to try to answer any, but representatives of the Bureau of Insurance are here to answer some of your specific, more specific questions. Again, just reminding you that this was a bill that was considered by the HCIFS committee in the 129th legislature. It was introduced then as LD 2026. That bill was reported out by the committee with unanimous recommendation ought to pass. So there were no amendments made to the bill as part of the committee process. But again, the bill ultimately was not taken up in any special session before the end of the 129th legislature. I briefly mentioned that there is a provision in the bill which provides that documents filed by an insurer with the superintendent would not be public records if those records would be confidential under the laws of that insurer's jurisdiction of domicile. That's a provision on page 6 of the bill. As we talked about with regard to LD 5, any legislation that proposes a new public records exception must be reviewed by the Judiciary Committee. So if the committee moves this bill forward with a favorable recommendation, it will go through this review process in the Judiciary Committee. Again, they completed this process last session with regard to LD 2026 and recommended no changes. So the expectation would be that their analysis would be the same this time if this bill moved forward to them. I mentioned that there are also some provisions in the bill that authorize the superintendent to adopt rules. The rules under existing law are designated routine technical, and as we talked earlier about the distinction between routine technical and major substantive rules, it is within the committee's purview to designate those rules as major substantive if you thought that you wanted some further legislative review and an ability to approve those rules before they can finally be adopted. Lastly, and I think we talked about this also earlier with regard to LD 5, as the bill is drafted, LD 6 would also take effect 90 days following adjournment of the first regular session. So the committee might consider whether or not you would want to add an emergency preamble to this bill, given the delay in the legislature's ability to consider the legislation, and that typically model laws at the NAIC are part of the Bureau of Insurance's regular accreditation process that they go through with the National Association of Insurance Commissioners. I'd also just noted for you, there were two pieces of written testimony that came in, and these parties did not testify at the public hearing. Both submitted testimony in support of LD 6 from Lloyd's of London and from the American Council of Life Insurers. Finally, the fiscal information, the Office of Fiscal and Program Review has determined with the input from the Bureau of Insurance that if the bill moves forward, there is no fiscal impact. I'm going to stop sharing.
Thanks, Colleen. Okay, so with that presentation, thank you for that. I will open it up for comments or questions from the committee. Yes, Representative Quint.
Thank you, Madam Chair. My question goes back to the same question that I asked on Tuesday, and I didn't know if anyone had information brought forward, and that goes with the cybersecurity that would be involved with this, since we're dealing with insurance companies actually in other countries now, and what the procedures are for implementing safety measures for our people here as far as their data being protected. Anyone get?
Yep, Colleen, do you want to answer that, or should we ask Ben Yardley or
Sure. It might make sense to defer to the Bureau of Insurance. I know that Bob Wake is here on the call, and so is Eric Chapa, and I think Mr. Wake has his hand up and he can take that question. He's the general counsel at the Bureau of Insurance. But you might want to bring all of them, maybe all three of them into the Zoom.
Sure, I'll do that now.
Yeah.
Sure. Whoops, they're moving around here as I. Okay, great. So the Bureau is going to be joining us, and I think they'll be able to address your question, Ms. Quint. So Mr. Yardley, Mr. Wake, Superintendent Chapa, the floor is yours to sort of respond to Representative Quint's concern.
Well, I would say that as noted at the public hearing, there usually isn't a lot of sensitive personal information that's transmitted from the ceding insurer to the reinsurer. However, under their own domestic laws, reinsurers, whether they're in or out of the United States, are responsible for protecting all the confidential information they receive. As you may be aware, many of the non-US reinsurers are located in Europe, which also has very strong protections. But ultimately, the domestic insurer remains responsible for making sure that all the personal information, all the sensitive information they obtain, wherever they send it, remains protected. Whether it's to a foreign reinsurer or a vendor. And if Senior Staff Attorney Yardley wants to elaborate on this or discuss it in the context of LD 51, I would let him chime in.
Yes, Mr. Wake has covered it, and this is exactly the kind of issue that that LD 51 is directed at, the relationship between insurers and the parties that they contract with to support their mission.
Mr. Yardley, would it be fair to say that LD1 gives the Bureau additional or shores up the Bureau's tools to ensure that that issuers, insurance companies are appropriately monitoring their other entities that they work with? That's the purpose of the bill?
LD 51, yes.
Sorry, I meant LD6. I misstated that. I apologize. That was just a misstatement on my part. I meant LD6. LD 51 has something to say about that as well. But focusing on LD6 with regard to reinsurance, this just gives the Bureau additional tools that won't be preempted by federal law in order to make sure you can continue to regulate that relationship. Is that right?
I think that's correct.
Okay. Representative Connor.
Thank you, Madam Chair. Just in a continuation of Representative Quint's question, in my rudimentary research on the topic, it said that the reinsurers are entitled to full access to the original policy files. Is there any type of federal law that I'm obviously not aware of that states otherwise? Because in my opinion, if we're doing this, I think that the main people should at least be kept abreast of the fact that their policies potentially could be in the hands of a foreign reinsurer. And so I just think it would behoove us to at least mention that if that is the case.
Well, reinsurance already exists. It is a thriving market. And if we look in the 2200s at the main privacy protection law, that already discusses the terms under which insurers can disclose personal information as necessary. Both that state law and federal laws such as the Gramm-Leach-Bliley Act and the HIPAA privacy regulations do require notice to consumers of how their information might be shared and ways to block unnecessary sharing.
Right.
Okay. Thank you, sir.
Yeah. Reinsurance isn't what's being permitted by this bill. It's sort of more of an an update to the ability of the Bureau to regulate reinsurance, I think.
Right. This bill doesn't change the terms of the reinsurance contract itself. It relates to how financial regulation of reinsurance is conducted and the extent to which the reinsurer can be required or not required to post collateral for the benefit of the ceding insurer, but the underlying policyholders aren't affected either way by this bill.
I understand, Madam. I'm sorry, Madam Chair.
Representative Connor, go ahead. Yes.
My concern is reinsurance going on now through foreign entities? Or I understand that reinsurance is going on domestically here in the States, and I don't think too many of our citizens would mind knowing that their information is, being used by a reinsurer here domestically. But I think if we're starting to talk about a foreign entity having access to that information, if it's being accessed, I think it would be good to let the public know. But if this particular bill is really talking to the fact that the information by the insurance companies can be minimized, if the private information is minimized here locally and they're only giving certain information to the reinsurer, it would be a little different. Is that what this is doing?
Well, this bill enhances regulatory cooperation between the Bureau and other U.S. regulators and the domiciliary regulators of the reinsurers. And international reinsurance isn't new. Lloyd's of London and Swiss Re and Munich Re, these companies have all been major players in the global reinsurance market for more than 100 years. And frankly, United States insurers often depend on the protection they provide, and we provide similar services to foreign reinsurers, to foreign ceding insurers, to keep something like a fire in California or an earthquake in Japan from devastating the market in the immediate location where it hits. And it does work in both directions.
Thank you. Thank you, Madam Chair. That's all I have.
Okay, great. Superintendent Chapa, would you like to add anything?
If I can unmute, yeah. I was just gonna, Bob kind of beat me to the punch. I mean, reinsurance, it really, especially with the climate change and everything that's going on globally, it's really critical. I mean, it's quite amazing if you step back and you look at the wildfires in California, tornadoes in the Midwest, and the hurricanes. You've had few, if any, insurer insolvencies, and that's a direct result of reinsurance. It's very, very critical. And the other point I want to make, this is an international agreement, and I know Senator Sanborn has mentioned it. If enough states don't pass it, we stand the risk of being preempted by the federal government, and that's something we're really, I'm really opposed to if we can help it.
Right. Great. Yeah. So reinsurance is actually needs to be international, if I'm understanding what Mr. Wake and Superintendent Chapa are saying, and has been international for 100 years in order to spread risk globally so that particular events don't devastate any particular insurance market. Is that a fair summary?
It was famous that Lloyd's of London helped save the domestic property insurance market after the San Francisco earthquake and fire in 1906.
1906, yep. Great. Okay. Are there any further questions from Representative Quinn, Representative Connor, anybody else? Representative Connor, yeah.
Yes, I was just questioning, and I completely agree that I understand that reinsurance has been around for quite some time. My question is, has it been around for just as long in the health insurance industry as it has been with the property and casualty insurance? I think we're talking a little bit different information than when we're talking about people's, private health insurance information versus their property information.
Anyone from the Bureau want to address that?
I'll start and Bob can weigh in. I mean, reinsurance is used in the health insurance industry. There's no question about it, but it's very important to, as Bob Wake mentioned, an insurer cannot offload its responsibility to protect the data by contracting with a reinsurer. In fact, they're responsible to do their due diligence to make the reinsurer or any third party they contract with complies with HIPAA and complies with the data security provisions that are in the state. Your supposition is right though. Reinsurance is used differently by health insurers than in the property casualty market, but they do use it. It's generally like a lot of self-insurers in this state purchase reinsurance. It's called excess insurance, but it is used. But that's usually a commercial transaction between an employer and an insurance company. But it is used, yes.
Yeah, there isn't nearly as much international reinsurance in the health market, and there are very stringent regulations at both the state and federal level that govern the transfer of personal health information to anyone. And frankly, I would expect that given the privacy regulations under which they operate, a reinsurer in Europe, even if they had a treaty with the United States insurer, wouldn't want to be collecting a lot of personal health information.
Yeah.
Thank you, Madam Chair. That's all.
Great. Thank you, Representative Connor. Representative Quint, go ahead.
Thank you. That gave me some clarification. The one question though that I'm not hearing answered is if there is by chance some problem, a cybersecurity problem like what we had here with Federal Blue Cross Blue Shield, all of our data getting released. I was one of the people affected by that. Is there something in place that if that happens in Europe that they would be reporting to us here so that we would have that information here? Because if they report it there, that's completely different than having something reported here. And I just wanted to see if there's a chain of command that's gone through to ensure that if data was breached, we would be notified.
Yeah, the seating insurer in Maine, the company that has the relationship with the Maine consumers, would be reporting it. They'd be reporting it now under the Notice of Risk to Personal Data Act, and LD 51 would strengthen many of those requirements. And our privacy guru, our cybersecurity guru, is nodding.
Okay. Are there additional comments from other members of the committee? Okay. So by request, I am going to, Representative Tepler, go ahead.
Thank you, Madam Chair. I'm wondering if Colleen can provide the committee at some point with EU internet security regulations, because I believe that they are actually above and beyond internet security regulations from the US, and if that's helpful to the committee.
Sure, yeah, they're much more stringent than they are here. Okay, so by request, I am going to suggest that we table this bill rather than voting on it today so that everybody has time to digest the answers to the questions that you received today. And we'll probably pick this back up we will definitely pick it up next week. TBD on whether it's Tuesday or Thursday. I have to look at our calendar, but we will send out a work session notice to let you guys know which day we plan to pick up LD 6. So with that, I move to table, and I need a second.
I'll second.
I see Representative Morris has seconded, and this is a vote we can do just with a show of hands. So if Representative Evans, if you turn your video on, and we can just raise our hands and keep them up in the boxes so that our clerk can see that we have unanimity on the motion to table if Mr. Evans, if Representative Evans can get yeah, there we go. He can just put his hand up. Yeah, perfect. Great. So the vote is unanimous of the committee members present. And so LD6 has been tabled. And now I'll open a work session on LD 51, an act to enact the Maine Insurance Data Security Act. And I will turn it over to Colleen for her.
Okay. I think everybody should see LD 51. How's that look for size? Should I enhance it a little more?
Yep, that's better.
Okay,
yep.
Great.
Great, thanks.
Okay, so LD 51, as we talked, just alluded to, is another bill from the Bureau of Insurance. It's an act to enact the Maine Insurance Data Security Act. It would add a new chapter to the Maine Insurance Code. It would, if enacted, it does apply to insurers, insurance producers, or agents and other entities licensed by the Bureau of Insurance. The bill would establish standards for data security and information systems, and for the investigation and notification to the superintendent of insurance of cybersecurity events, which are defined in the bill. Entities licensed by the Bureau of Insurance would be required to develop, implement, and maintain an information security program based on the entity's ongoing risk assessment for protecting consumers' personal information. There is an exemption in the bill for licensees with fewer than 10 employees. Insurers that are domiciled in Maine are required under the provisions of the bill to annually certify that they comply with all of its provisions. As we talked about with all of the bills that we are working today, this is another bill that was considered previously by the 129th legislature. That iteration was LD 1995. It was voted out of the HCIFS committee to pass as amended, but again, was not able to be taken up by the full legislature before the end of the 129th legislature. The language in the committee did develop an amendment to LD 1995 that was put together with the input of stakeholders, and the version of the bill you see, LD 51, reflects the committee amendment that was supported and reported out for LD 1995. However, I think as you heard at the public hearing, there were some additional changes that were considered by the committee and suggested by some of the insurance company representatives, but were not ultimately included in the final language of LD 1995 and have also not been included in LD 51. Mr. Wake made reference to the existing provisions in current law in Title 10, which is the Notice of Risk to Personal Data Act. Insurers, like other entities in the state, are subject to these provisions currently. That law requires an insurer who maintains computerized data that includes personal information. If they become aware of a breach of the security of their system, the insurer is required to conduct in good faith a reasonable and prompt investigation to determine the likelihood that personal information has been or will be misused. And they are obligated to give notice of that breach following discovery or notification of it to a resident of Maine if misuse of their personal information has occurred, or if it's reasonably possible that misuse will occur. The language of the current law requires that the notice must be given, and the phrase in the statute is as expediently as possible and without unreasonable delay, consistent with needs of law enforcement. There is an opportunity or an availability under the law for law enforcement to delay the requirements for providing notice during a law enforcement investigation. But if there is no delay of that notice at the request of law enforcement, the notice, the statute does put sort of an outside time frame for when that notice must be provided. which is no more than 30 days after the insurer becomes aware of a breach of security and identifying its scope. The current law requires notice to be given to the appropriate state regulator. So insurers now would be required to notify the Bureau of Insurance in addition to any notification that they would be required to provide to their insureds. LD 51 includes some additional notification provisions regarding cybersecurity events to the superintendent of insurance and doesn't conflict or change any of the underlying responsibilities of an insurance company to provide notice under the Notice of Risk to Personal Data Act. As you heard at the public hearing, some of the insurance company representatives did suggest that the committee consider further changes to the bill, and I've just kind of bullet pointed them here for you on the page. They include clarifying the definition of a cybersecurity event and information system by adding some specific references to non-public information, clarifying the intent of the legislature that the law would establish exclusive standards for data security that insurance companies would be subject to, adding what's called safe harbor language to recognize compliance with substantially similar laws in other states. So if an insurance company was in compliance with a law of another state, and I think New York State was the one that was noted as part of the testimony, then compliance with New York laws would be deemed to be satisfactory compliance with the provisions of the law that you have in front of you. They also suggested that additional language be built in to the notification provisions so that there be a materiality factor to determine when notice to the Bureau of Insurance must be provided. And again, the concern there relates to whether insurers or other entities would be required to report too much information or too many times to the Bureau of Insurance pursuant to how a cybersecurity event is defined. So the suggestion is that notification would be required when there's a demonstration that there's been a sort of a material harm or material event related to someone's non-public information, and that then would be the requirement that would trigger notice to the Bureau of Insurance. It was also suggested that the language around when an insurer is required to provide notice to producers, that be amended slightly to remove the ability of the Bureau of Insurance to provide discretion as to when that notice would be provided. The suggestion being that notice should be provided to producers at the same time as notice would be required to be provided to any consumers. The Maine Association of Health Plans suggested some additional clarifications to the confidentiality provision. And then lastly, it was suggested that the committee consider extending the effective dates of the new chapter in the insurance code from January 1, 2022, and certain provisions become effective January 1 of 2023, moving those out an additional year. You also heard as part of the testimony that the bill is based again on a model law that was developed by the National Association of Insurance Commissioners. The model law has been adopted in 11 states, and I just listed those states for you here. It's also under consideration this legislative session by at least 6 states, including Maine, and there may be others as legislative sessions in other states start to move forward. I would note for you that 10 of the 11 state laws that have been adopted have made various changes to the model depending on the state. So these states aren't adopting the NAIC model sort of as is without making certain changes. And then there have been 8 states that have included sort of an additional materiality factor, if you will, as to what triggers notification to the Bureau of Insurance. Again, as with both of the other bills we've considered this morning, LD 51 does include a provision that would provide that documents submitted to the Bureau of Insurance are not public records, if those public records would be confidential under the laws of another state. And I apologize, there's a typo here because I'm referring to the to LD 6, but there are provisions for confidentiality in LD 51. And because it enacts new law related to that exception, this would have to go through a process of review in the Judiciary Committee if the committee reports the bill out favorably. And again, the committee did review the version of this bill that was considered last session, LD 1995, and approved that language as it's drafted in LD 51. Finally, with regard to the fiscal information, the Office of Fiscal and Program Review has indicated that any additional costs to the Bureau of Insurance and to the within the Department of Professional Financial Regulation to adopt the changes in the bill are expected to be minor and can be absorbed within their existing budgeted resources. I'm gonna stop the share and get it out, and I'm happy to answer any questions. And I believe you still have Mr. Yardley from the Bureau of Insurance here who can answer any of your specific questions, as well as Superintendent Chapa and Mr. Wake.
Great. Thank you very much, Colleen. I appreciate that thorough and context for us. Okay, so I'm going to open it up to questions from the committee or comments, either one. Representative Morris.
Yes, thank you, Madam Chair. Colleen, would it be possible to get a copy of those materiality standards in those other states and what the amendments were in the 10 states that did amend it?
Yes, I did share that information with you. I shared excerpts from the state laws. Mr. Garrity had provided some information, so I did email that to the committee previously, but I'm sure you might have lost it in the all the bombardment of emails that I'm sending to you on all of these bills, but I'm happy to do that again. Yes.
Okay, I probably did lose it. Yes, with
Yeah.
all the bombardment with 2 committees and everything. Yes, but
Yep.
I'll be happy to look for it. Yep.
Yeah, I will do that.
Great.
I'll do that again.
And just for the committees, I think I'm remembering this right, Colleen, for the committee's sort of context, we did consider adding a materiality provision last session, and I think decided against it. Is that right?
We did. I mean, I think that there's sort of, it was considered within the sort of internal stakeholder process in the meetings that the Bureau of Insurance had with interested parties at that time. It wasn't included in the amendment that the Bureau brought forward to the committee. And then again, at that work session, the committee did have further discussion about adding it at that time. And the committee decided not to in the 129th. Yep. So it is a familiar issue, and that was raised previously.
Got it. Representative Bleier.
Yeah, the question I had was the concern that Bruce Garrity had on these non-public type of firewall breaches. How often do those happen? Is that like a daily type of occurrence, twice a year? I'm kind of curious if anybody could answer that question.
Doesn't anyone who's currently attending our meeting have an answer to that question? Mr. Garrity has his hand up, but let me give the Bureau a chance to answer first. Mr. Yardley.
So I have not seen, well, of course, we get reports of breaches of private information as is defined in the Notice of Risk to Personal Data Act. But I have not seen reports of that involve public information. That's what I can offer.
Okay, let me allow Mr. Garrity to answer with his thoughts since he's raising his hand. Mr. Garrity, welcome to the meeting. We've moved you from some part of the back row back to your proper spot in the front row. And if you have an answer for Mr. Bleyer's question, we're open to it.
Thank you, Senator. My understanding is that efforts to breach insurer firewalls are, I can't say constant, such as like more than once a day or anything like that, but it's a very common occurrence. Certainly more than once a month, probably more like at least once a week. I don't have any exact numbers, but I can try and get the committee more information on that. But it is a constant thing in terms of efforts to get in.
Okay. Superintendent Chapa.
We certainly don't have the numbers as the representative requested, but I would point out we're not talking pings here. We're talking actual breaches. And you know, our position is still, we don't see a distinction between public and non-public information. It's the fact that the system has been breached that we're concerned about. Again, the attempted breaches that they prevent, we're not asking for that data. So that I just want to make sure the committee's, that's a very important point in my opinion.
Okay. Representative Morris's hand, I think, was next.
Yes, thank you, Madam Chair. I just wondered if we had any, I guess the questions to Mr. Garrity is, they must keep track of these instances either way, whether they have to report them or not, they must keep track of the incidences anyway, correct?
I would assume that they do, yes. I haven't asked for any data on that, and I can try and get it for the committee.
Okay. I think Representative Tepler is next.
Thank you, Madam Chair. My question is, I had asked someone, I believe it may have been Ms. Peltro, who is not present, to provide information at the work session, which we're in right now, regarding whether there's any entity other than this proposed law that the Bureau of Insurance that's tracking breaches of insurers' information in the main space. And Ms. Peltro said she'd get back to me on that, but she's not here. I'm wondering if anybody else has that answer.
Does anyone at the Bureau have that answer?
I don't think we do, Senator Sanborn and Representative Tepler.
Okay. I think it might have been a rhetorical question as well. So perhaps that is the point.
I'm not entirely rhetorical, Madam Chair, but certainly it expresses my concern that I feel that we need to have someone tracking breaches.
Okay.
And not just breaches of non-public information, but the pattern of breaches of firewalls of insurance companies.
Yeah, Mr. Yardley, to follow up.
Thank you, Senator. I can tell you that I think I mentioned this at the hearing. We do keep track of the reports that we receive, and so we have those records, and we have general. I attempt to categorize them by the type of breach. For a long time, it was theft of hardware, and now it's moved into what's called phishing and social attacks.
And Representative Connor, I see your hand, but I also have a couple others from the front row who want to answer this question. And I am trying to stick to the virtual meeting as close to the way we would typically run work sessions as I can, which is to say, if you're in the room and you have valuable information to provide, we will recognize you up to a point. And so I've got Ms. Awesomefork coming in, who I think was going to answer Representative Tepler's question before we move on.
Yes, thank you, Senator. Chris Awesomefork with Anthem Blue Cross and Blue Shield. Just to try to attempt to respond to I'm promoting Representative Tepler. In addition to the requirements today under Title 10, where we would have to report breaches to the Bureau of Insurance, we also have to report certain breaches to the federal government under the HITECH Act requirements. Off the top of my head, I cannot tell you what those requirements are. I don't remember them, but if that's important, we could certainly get that for the committee. But those are the two things that come to mind today that would apply to us.
Okay. Thank you, Ms. Awesomefork. Mr. Sultan also has his hand up, I think, prompted by that same question, and just in the interest of allowing the entire front row in for the time being, we will do that. So I'll let Mr. Sultan come in and see if he has if he's still on that same topic, and if not, we'll move on to Representative O'Connor. Excuse me.
Yeah.
Welcome.
Welcome, and thank you, Senator. Ms. Awesomefork pretty much answered it. I mean, just a reminder, we had one of the earliest privacy statutes in the country. And so we've had this obligation to report to the Bureau for a long time. So we've been tracking all of this and for quite some time.
Okay. Representative Connor.
Thank you, Madam Chair, and no problem at all. I completely understand. My question is in regards to materiality. In my limited experience in the outside world, most companies have multiple systems. They'll have a CRM system, they'll have a vendor system, they may have their own payroll system in addition to their customers, their clients' information. Is the Bureau's intention, if let's say the company's HR department was hacked, is that something that they want reported? If it had nothing to do with their actual client information, is that what the Bureau is asking for? Is any breach of any system, regardless, they want that information reported? Is that a correct statement?
I'm going to let somebody at the Bureau answer.
This was something that we talked about last year, and the answer is yes, because systems of that nature that aren't obviously public facing do have a profound effect upon the, taking an insurer as an example, profound effect on its ability to carry out its business.
Superintendent Sciappa.
And I just want to add to what Ben said. I mean, some of the phishing stories you read about and we've experienced is they get into the system someplace and then they migrate to other places. So getting in, is what we want to know about, because that, again, that can lead to bad results if they migrate and get into places where they get to non-public data.
Thank you, Madam Chair. That's all I had.
Okay, great. I've got somebody's hand up, but I can't tell whose it is. Hang on. Oh, no, I think we're good. I think it was Superintendent Sciappa's hand. Okay. Are there additional comments from the committee? Representative Melrano.
Thank you, Madam Chair. This is sort of changing gears a little bit here. Do we have an opportunity here to lessen the amount of time that licensees have to notify consumers? I know the focus is more on the BOI, but it does seem like a long time, 30 days. And I'm wondering if we want to visit that at all in this legislation.
So I don't think the time frame to notify consumers is governed by this legislation, but Colleen, do you want to weigh in?
Yeah, I just would want to clarify that the Notice of Risk to Personal Data Act, the standard of when notification is required in the statute is as expediently as possible and without unreasonable delay. But the statute requires that the maximum amount of time, it can't be no later than 30 days. So the statute, as it's drafted right now, is intended to require entities like the Bureau of Insurance or other entities that are subject to that act to notify sooner than 30 days, but 30 days was put in as sort of the outside possibility of how long an insurer could take to notify. So the standard actually for when notice is required is that as expediently as possible and without unreasonable delay. And then the outside limit is that 30 days.
Thank you.
Does anybody from the Bureau want to add anything to that? Okay, great. Anyone else want to weigh in or make any comments? Okay, seeing no further hands, I have again at the request of members, I'm going to table this rather than voting on it today to ensure that everybody has the opportunity to digest the information that they received today. We won't always be doing this where we have 2 work sessions on a particular bill, but as we're just getting going here and have a lot of new members, I'm happy to extend that courtesy at this point. And so I would entertain a motion to table.
So moved.
Okay, and a second from Representative Tepler. So again, it's a show of hands vote, and you can put your hand up in the screen. All those in favor of tabling LD 51 and returning to the work session later. Okay, so it's unanimous of the members present. And so with that, I think I just have a couple more items of business this afternoon. One is to record our vote on the budget of folks who were absent this morning or not on video this morning. I'm going to let the folks from the Bureau head back to the attendee role. And okay, multitasking here. I think we have Representative Melrano needed to record a vote on the budget. And I feel like there was someone else and now I don't remember who. Christian?
Senator Brenner, I believe.
Oh, great. And they're both here. Perfect. So the motion was a straw vote. It's not an official opinion of the committee in a committee report fashion, but it's a straw vote on our approval of the curtailments as presented to us yesterday by the AFA, or by the department at the AFA hearing that we attended yesterday. And so did we do a show of hands? I think we just did a show of hands, right? Yeah, so if Senator Brenner and Representative Melrano are okay with that, if you just show your hand to Christian, he can record your vote as if you were present at our first round of voting.
Great.
I think that was the thing I remembered I needed to circle back to. What else what other business might we have, Colleen?
I don't think anything from today. I will follow up next week or actually probably tomorrow with a draft of the memo to the Appropriations Committee, and then quickly during a work session next week, you can sort of give your final approval of the language as drafted before we report to them February 5th. And then the last thing would just be a reminder about our meeting on Tuesday. We have public hearings scheduled, but we're going to begin at 10 with a briefing from the Bureau of Insurance on the federal surprise billing law, because one of the bills we're having a hearing on proposes to make some further clarifications to our state law that was introduced by the Bureau of Insurance. So.
Perfect. Great. Does anyone on the committee have any items to bring forward at this point before we adjourn? All right, great. Seeing none, I'll entertain a motion to adjourn. And I see Representative Connor's hand up and Representative Arford has seconded the motion. All those in favor? All right, we are adjourned.